Item 5, sir.
Yes, Mr.
Read,
Pradeep.
please.
Sir. Yes. But I was on page 24 of my written submissions. Because I left at the article written by Maloti, then the Honorable Law Minister.
Yes. Honorable Finance Ministry.
No, that was an article written in response to certain concerns which were raised and which was published in Press Information Bureau. It's available, my lord, in public domain. But I was reading from volume 2 at page 14, my lord. Kindly read from page 14, volume 2. Then I'll come back to my written submissions.
Page?
Page 14, 1-4 of volume 2, the title, my lord, for identifying the letter, Press Information Bureau, Government of India, Ministry of Finance. Your lordship gets me? Please. Lord, kindly come to, allow me, my lord, to read the last para, because I have read, my lord, till 10. I do believe, my lord, I do believe that donations made online through checks remain an ideal method of donating to political parties. However, these have become a very popular, but this has not become very popular in India since they involve disclosure of donor's identity. However, the electoral bond scheme, which I placed before the Parliament a few days ago, envisages total clean money and substantial transparency coming into the system of political funding. A donor can purchase electoral bonds from a specified bank only by a banking instrument. He would have to disclose in his account the amount of political bond that he has purchased. The life of the bond would be only 15 days. A bond can only be encashed in a pre-declared account of a political party. Every political party in its returns will have to disclose the amount of donation it has received through electoral bonds to the Election Commission. The entire transaction would be through banking instruments, as against a total non-transparency in the present system of cash donations, where the donor, the donee, the quantum of donation, and the nature of expenditure are all undisclosed. Some element of transparency would be introduced in as much as donors declare in their accounts the amount of bonds that they have purchased, and all parties declare. But it is very careful, some element of transparency. How? Because we have to begin.
Mr. Mehta, in fact, I was just going through some paper. There was a very interesting discussion why the trust scheme came into force, how the trusts, in fact, in 1996, one big group, corporate group, with over 100 companies has set up a trust.
Correct.
And
Tata,
most,
let us, yes.
I didn't want to take it. So and the money from all those trust companies or the group companies will come in the trust, and then they will distribute and give it to different parties. The idea behind the trust was that the trust may be of 5 or more than 5. The money will come into the trust. The trust will then distribute the money. So nobody knows. The companies will give instructions to the trust to give to A, B, or C party. But nobody knows which company has given that money. But what happened was 2013 scheme of the Election Commission made it mandatory to disclose which company is directed to give the payment. So that scheme virtually failed because of that. It had a contrary impact.
Yes, my lord, but still, as a matter
that's somebody's point of view. I'm not saying that's a right point of view or wrong point of view.
No, correct, my lord. But as a matter of fact, my lord, my lord, the trust scheme still continues. One can have trust, and the same system can be adopted. Few companies can gather together and create a trust. Trust is a misnomer. It's a Section 25 company. Nothing turns on that, but it is nomenclature is trust. Lord, but one fact, my lord, inadvertently, my lord, we admit that the moment the question of disclosure of the donor comes, the scheme fails. As, my lord, it failed in trust. Because that is the disincentive, my lord. the incentivizing factor for the purpose of paying by cash is, my lord, secrecy, the confidentiality. Secrecy and anonymity is a negative connotation. I am using the expression confidentiality. My lord, my lord, what I am submitting is that Honorable Finance Minister is also saying that we have started a process, may not be a foolproof process. Some element of transparency would be introduced in as much as all donors declare in their account the amount of bonds that they have purchased and all parties declare the quantum of bonds. How much each donor has distributed to a political party would be known only to the donor. This is necessary because once this disclosure is made, past experience has shown donors would not find the scheme attractive and would go back to less desirable option of donating by cash. Look, this is the experience, the view of the lawmakers. That if this confidentiality is not ensured, people go to the earlier regime. In fact, the choice has now to be consciously made between the existing system of substantial cash donations, which involves total unclean money and is non-transparent, and the new scheme which gives the option to the donors to donate through entirely a transparent method of check, online transaction, or through electoral bonds. But it is, if I want to disclose my identity, I can pay by check. It's not taken away. I don't have to go through this electoral bond scheme. I can still pay by RTGS, direct banking transfer, or through check. But then my identity would be disclosed. If I wish that to remain confidential, then electoral bond. But I have, very seriously, and I am bound to, considered, the concerns which your lordships have shown as custodian of fundamental rights of the citizens. And the government is proud about it, that your lordships are concerned. And my lord, I have some solutions, my lord, to offer, so that that concern also can be addressed. And your lordships would find the bona fides of the government that we really do not want to know who has donated whom what amount. Let the confidentiality remain complete, except under the court order. I'll say, my lord, as and when, my lord, that a part of the scheme comes.
But that, Mr. Solicitor, you know anyway who has donated what amount. The moment an electoral bond is tendered to a political party by a constituent,
The party would know.
the party knows it.
Correct, my lords. What the donor doesn't want to is, as a contractor, I donate to, say, Congress party. I don't want BJP to know because it might form a government in the next
I've
election.
forgotten I'm not in the Congress party.
You appear for a Congress person
Maybe
from
so.
Madhya Pradesh,
Maybe
and
so.
therefore I'm saying.
You are appearing for a government, you're not part of that party.
Absolutely not.
So I'm also not
No,
part
I am just putting
just-
myself as a
of
contractor.
that example I thought was a bit.
Yes, yes. My learned friend's client is a leader of a Congress party
That's all right.
in Madhya Pradesh. Therefore, I am giving the example of Madhya Pradesh, and I am saying that a contractor wants to donate to Congress would have an apprehension that BJP might continue to be in power, or vice versa. If he gives donation to the ruling party in Madhya Pradesh, he might have a element of fear that Congress might form the government. That confidentiality the donor wants to ensure. And that is not for me to judge. That is for the lawmakers to judge. And the lawmakers felt in the parliament that this is the most incentivized way of black money generation and black money payment in the political process. That's their view.
But what about the voters' right? As Justice Chagla has pointed out
My lord, let me conclude.
long years back.
My lord, that is a wider choice, my lord. But that would be a separate debate. My lord, voters' right, my lord, is to know what party gets what information. I would not choose to vote for a particular party because Mr. X, the contractor, has given electoral contribution to a party. Well, that's an utopian dream. That's an idealistic dream. We have to formulate a policy based on practicalities involved. Well, otherwise, we will not be able to, my lord, your lordships have a very heavy responsibility on your lordship's shoulders. That is encouraging clean money to come into the system and discouraging those elements which compelled the people to use the black money. So, my lord, the transparency, democratic principles, right to know, etc., they are idealistic things, and I bow down to those principles. But when we formulate a policy, we must formulate a policy, my lord, which balances purity of election is supreme over right to know. Voter votes not based upon which party is funded by whom. Voter votes based upon the ideology of the party, the principles of the party, the leadership of the party, the efficiency of the party, and how, my lord, the business houses vote, whether this party's government is giving me a sufficiently good environment to secure my investment. It's not always quid pro quo. As a businessman, I would choose that this party government, whenever it is formed, there is red tapeism, there is corruption, there is interference by the ministers, there is interference by the MLAs. As against that, X party, when it forms the government, it is policy-based decisions, not individual-based decisions. My investment is secured. There is a business-friendly environment, less red tapeism, and therefore I would like this government to be formed. And that's the business interest of every business owner. I'll read further, because the Honorable Finance Minister was also very categorical that we are not coming out with a foolproof scheme. There may be some lacunas here or there, and we are ready to improve. Please see. In fact, I have read that while all the three methods involve clean money, the first two are totally transparent, and the electoral bond scheme is a substantial improvement in transparency over the present system of non-transparency. Please see, my lord, this is what, my lord, the honest government, my lord, framing a policy for the betterment of the people and in larger public interest would say, and rarely says. This is what the Honorable Finance Minister said. The government is willing to consider all suggestions to further strengthen the cleansing of political funding in India. It has to be borne in mind that impractical suggestions will not improve the cash domination system. They would only consolidate it. Lord, the words are, if I may use the expression, prophetic. That this is substantially, we are trying to reduce the element of black money, clean money coming in the system. There may be lacunas. We are ready for suggestions. We are ready for improvement. But if the suggestions, as the Honorable Minister says, are not practical, it would defeat the object. Now, my lord, coming back to my note, my lord, at page 24.
Volume?
My lord, 2A.
Yes.
Lord, your lordships may now kindly come to 25. I'll explain the scheme. And my lord, possibly, at least I will be able to satisfy your lordships to convey that bona fides of the government are writ large, and from one or two suggestions which I will make, your lordship's conscience would be satisfied that scheme is, designed to ensure that the ruling party knows. It's not even the intention. The ruling party doesn't want. That's the stand of the government. Whoever is the ruling party should not know about any of the details which others are not knowing. Who donated, to whom, what amount, the ruling party should not know. And I will not point that out. And if necessary, my lord, I have some suggestion, my lord, which may, my lord, perhaps, my lord, subject to your lordship being satisfied, take care of your lordship's concerns.
Mr. Solicitor, is it your contention that under this scheme, the ruling party does not know who its donors are?
No. The party every party knows who their respective donors are.
Yes.
Yeah, my lord, confidentiality is from other party, my lord. I'm sorry, my lord, I am unable to convey the heart of the matter. My lord, if I donate to Congress, the Congress knows Tushar Mehta has donated.
Right. But you don't,
My worry
you
is
don't want another party to know.
BJP should not know so that I don't get victimized. That's the purpose of confidentiality. My lord, technically, I can say, my lord, Mr. Bhushan has given this example that even ruling party can, any party, my lord, why ruling party, any party can feign ignorance. That somebody came and in my Dropbox not in the digital sense, in the ballot box, in the postal box, there was an envelope. An envelope contained 100 crores. Nobody donates like this. We give money like this only in pilgrimages. We don't, people would not donate, my lord, anonymously. In Srinathji, my lord, people would donate 100 crores without any name. It would be an anonymous donation because that is, yes, Tirumala. That's what I'm saying. But that is, my lord, again, idealistic way. Practically, the party.
Even that is not idealistic. Because the assumption is that the Almighty knows who has put money in the hundi.
Your Lordship, I bow down, my lord. There is no confidentiality. There is no confidential, my lord, even the person also knows why he is donating. That is reflection of the fact that there is a line in Ganges for, my lord, because they know कि बहुत पाप किए धोना जाना पड़ेगा. So people also know that. But, my lord, the party who receives knows who has given. That you can never, my lord, come out of. There cannot be any system where the donor and donee each other would not know.
But then, so Tushar Mehta, if this is so, why not make everything open?
But, my lord, then the purpose is defeated. As I, my lord,
As it is, everybody knows about, or partly knows about it, partly they know about it. Only person who is being deprived is the voter. Your contention that the voters do not have the right to know after the number of decisions of this court. Maybe slightly difficult.
no, my lord, voter, my lord.
Because they would know that they should know.
Then I bow down and we go back to, my lord, the earlier policy.
No,
That's the only answer.
No, it's not like that. That's why we said we are not for a moment saying that, look, there are 3 or 4 considerations which are very important. One, the need to reduce the cash element in the electoral process. Very
It has
important.
reduced,
Right? Second, the need to encourage the use of authorized banking channels for that purpose,
Correct,
which is the only way you can reduce the cash element.
Correct,
That's the second consideration. Third, there is a countervailing consideration. Third is incentivizing the use of the banking channels.
Which is confidentiality according to us.
And therefore, according to incentivizing the use of the authorized banking channels should therefore result in greater confidentiality. But there is a fourth consideration, which is the need for transparency. And a fifth consideration, which is that this should not become a legitimization of kickbacks and quid pro quo between the power centers, whether in the states or in the center, and people who are really in that sense, they are benefactors of that power. They are supplicants.
I bow down.
Yes.
I bow down.
So all these. So when the balance is drawn between these, of course, the balance has to be drawn by the legislature and by the executive, not by us. We are quite conscious of that. But it's not therefore that you have an either or. Either you have this or you go back to an entire cash system. You can design another system which does not have the flaws of this system, which really they put a premium on put a premium on opacity. You can still devise a system which balances out in a proportional way. That's the point.
I'll just.
How it is to be done is for you to decide.
I'll just.
We will not step into that arena. That's no part of our function.
I'll just respond to Malod after showing the scheme. But let me respond the last point first, which is bothering your lordships. That this might be used as legitimized kickback. Well, first of all, whenever your lordships are considering a piece of, my lord, subordinate legislature like a scheme.
Because, in now these 5 considerations which I have listed out, you must now read in the perspective of how it has been implemented. First, there was a cap that your donation must be related to a percentage of net profits. A percentage of net profits meant that the company must be in a position to have net profits, and that you would donate 5% initially, then it became 7.5% under the 2013 Act. Now what have we done? Now we say that, well, it has nothing to do with whether you have net profits or not. In other words, the company may have zero profits, it may have zero turnover, but it gets a donation only for it gets a certain income or revenue only for the purpose of the donation. That meets
I'll
with
immediately say.
that passes muster.
I'll immediately say, and your lordships may clarify that if that is the any concern. It's the right concern that so far as the condition with regard to the profit-making company, that percentage of a net profit, a not profit-making company cannot donate. But I understand, because then it would be used as a shell company. That is one of the objectives. We have removed 2,30,000 shell companies from the system.
So what will you do then? You will bring about an amendment to the Companies Act, government
Let me take your lordships through this.
So you will move an amendment to amend the Companies Act to the effect that
amending, my lord, is a legislative function. I cannot make that.
But you have to move the amendment. If you
yes, my lord, or your lordships may, my lord, read it accordingly.
No, is the government making a statement that we will amend the Companies Act to bring back the position what it was, namely that this will be only a percentage of the net profit?
No. I'm not saying percentage. I'm saying profit-making company can only donate.
But tell us something. Assuming that it's a profit making, it may have a 1 rupee profit, it may have a 100 rupee profit.
Yes.
Why would a company, if you don't have a percentage,
yes,
why would a company, for what conceivable reason would a company donate 100% of its profits? Because you have to take the extreme case.
Yes.
That's why I give you a 1 rupee company, passes the threshold that I'm a profit making company.
I have two answers.
I have a 1 rupee profit, but I will donate 100 crores. Why would a company do that?
I'll not.
Therefore, when, it can't be that, the government says that, well, it can't be that we lay down under 142 the principle that so long as you're a profit-making company, you can donate as much as you want. The reason why these caps were introduced and that they stood the test of time were for a very legitimate reason. Namely, that you're a company. Your purpose is to carry on business. Your purpose is not to donate to political parties. And if your purpose is not to donate to political parties, you must donate only a small portion of your, assuming that that's an altruistic motive, which is, of course, not so, but we will not go into it because nobody is challenging the 1956 Act provisions, the 2013 Act provisions. We are now looking at today's challenge.
Yes. Well, may I respond to your lordship's concern? And it's a very valid concern, my lord. We share that concern. But what was the reason why that was removed? The experience had shown that in a given sector, my lord, for example, where the business environment should be business friendly, my lord, in terms of the administrative or political setup, some companies wanted to donate, say, 10% or 15%. Okay? Now there was a cap, 7.5%. What used to happen was that company would create shell companies. So I would, as a main company, donate 7.5%. And from that shell company, I would donate 7.5% to make it 15. With a view to discourage creation of shell companies, we have said that it is the company doing the business through the managing director, through the board of directors, which are trusted by the shareholders. And therefore, if they want to donate more than 7.5%, let them do it. Let that discretion remain with that. As a government or as a parliament, it's none of our business to prescribe that ceiling. They don't use more than 7.5%. So that was the purpose. The purpose was to disincentivize creation of shell companies to do what they wanted to do. But now you do it.
But that
number two.
You can disincentivize that
allow me to say
by having narrowly tailored provisions. For instance, that you must carry on business for a certain stipulated period. You must have a certain asset base. You must have a certain turnover. These are all, usually accepted yardsticks under the Income Tax Act to prevent a shell company from carrying on activity. That
Another-
you must
another-
have a certain degree of business turnover, capital, assets before you can
Yes.
donate. That makes sure that you don't have a shell company. You can put all these things in place. There's no difficulty. That will obviate your concern of shell companies.
I bowed. I bowed. Look, another thing which weighed with the government, and I'm just trying to satisfy your lordship's conscience about the positive approach with which, my lord, we approach this problem. Another,
Mr. Solicitor, we don't have to go into the motives of the government at all.
No, I'm giving the reason.
Fault. I mean, the constitutional court is no part of our function to deal with motives. I mean,
no, certainly. Your lordships may even deal with motive.
this is the rough and tumble of democracy in the country, which
I-
we respect,
Your Lordship, sir.
entirely respect. That's why we have this freedom of speech that all of us have in the court, outside the court. So we respect that process.
Which many a
The
time
point
we
is,
misuse.
no, but the point really is this. The point really is not that.
But
We
please,
don't want
another-
to go back now to a cash-only system. No, that's not the purpose of the court. All that we are saying is that do it in a proportional, tailor-made manner, which takes care of the serious deficiencies of this.
Now, my lord, another factor which weighed with the government while coming out this no cap policy was that if some party wants to donate more than 7.5%, and they do not wish to have a shell company also, what would be I'm posing a question to myself, what the company will do?
They will not donate.
No, that's the first idealistic option. But that was not,
But
that didn't used to happen. What they used to do was the balance, they want to donate 10%. The balance 3.5% would come in cash. Now, at least, if they donate 10%, the clean money comes in the system.
So which is not to say that the unclean money is not coming into the system.
see, we are in fact going into there are two conflicting rights in a way coming from. One is confidentiality, the other is check on kickbacks or quid pro quo. These are times.
Lord, I would, my lord, earnestly urge. Lord, I would earnestly urge, my lord, I would earnestly urge. Dealing with a subject, my lord, which is bothering everyone. Lord, to start with a presumption that every contribution should necessarily be a part of corruption may perhaps be a wrong, my lord, way of, my lord, looking at things. It may be that in some cases it can be quid pro quo. In some cases. But, my lord, the experience have suggested that in most cases, the vote, my lord, whoever donates, donors, be it individual contractor, businessman, company, trust, HUF, etc., they donate which kind of a government they want. Maybe out of 110, maybe kickbacks. I'll address that kickback part also.
But would that be valid if a company were to donate even 100% of its revenue? Is that guided by altruistic motives? We quite see. Everybody doesn't donate, as a kickback. Not at all.
Therefore, my lord, kindly, my lord,
And
do
we
not
also
see
have
this.
companies. We also have companies. All companies cannot be tarred with the same brush in India. You have corporate sector which has contributed to the productive assets of the nation. So
But
we are
look,
not.
they have
We are not at all saying that our
contributed
corporate
to
sector
the
is therefore
development
tainted.
of the
You
nation.
shouldn't make that assumption.
Well, only a minute, Mr. Sibal. Sibal, sir. No, there was something personal, not. It was not a fun or humor. my lord. Out of concern, I asked something, which I'll right now not share.
That's all right.
We had some concerns. I said, go to my chamber. That's all. Lord, so the idea was that instead of either shell company or paying by cash, let the clean money come into the system. And my lord, clean money has come into the system. Second, whether we like it or not, my lord, industrial houses, commercial houses, corporations, companies, they have, my lord, immensely helped, my lord, in the development of the nation. And now, my lord, as I have shown,
That's what I just said, that, we don't
so
start with the
everyone, my lord,
assumption that
does
our
not
corporate
pay
sector
by
is
kickbacks
tainted.
to, my lord, believe that they need electoral bonds to be used or any other factor to be used to influence the decision making would be, my lord, shutting an eye on the reality. Without that also, my lord, that can be done. And possibly practically, despite, my lord, this white channel being available, both channels might be used by some companies which are, my lord, not kind of good companies. But good companies, my lord, do decide to donate based upon their experience, whether in this regime of the political government, my investment is safe or not, whether the country is going forward or going backward, whether I am.
All right, Mr. Solicitor, we now understand this.
But
Can we do this to sort of, to carry the dialogue further? Should we go straight to the scheme? Because we'd like to hear you on the scheme.
Page 25.
Let's have a look at the scheme so
Page
that
25.
your argument on the scheme will be of value to us. This we have now seen that
Because your lordships
you've made your
have-
point, no doubt about it.
Lord, kindly, your lordships have the challenge to a provision which gives away or does away with the cap. Lord, I have given my answer for your lordships to. Lord, I think I am clear.
Yes, of course.
Now, my lord, the scheme. See the definition, my lord. And my lord, please read, my lord, as if it is for a bona fide reason and not to encourage or legitimize kickbacks. Please examine that. There may be 10% out of 100 where kickback is provided. Kickback can be the motive of the donor. Electoral bond means a bond issued in the nature of promissory note, which shall be a bearer banking instrument and shall not carry the name of the buyer or payee. Lord, I have already explained why this is, why this confidentiality. So I will not read the Lord, second part, second column is the object behind it. My Lord, object I have sufficiently, Lord, attempted to explain and therefore I will not repeat it. Please see, my Lord, authorized bank. My Lord, this is the entire policy produced, reproduced verbatim. I have not missed anything. So your lordships can read either from the policy or from here, but here it would be more convenient because I have given my object of each
That's
clause.
better, actually, you're right.
But there is no part of the policy is missed, my lord, in reproduction. Authorized bank means the State Bank of India authorized to issue and encash the bonds in the branches specified in Annexure 1 to this notification. My lord, we had options, my lord, of public sector banks and private banks. Obviously, we cannot choose private banks. In public sector banks, the largest bank with largest presence in the country is State Bank of India. Therefore, State Bank of India. There is a specific, my lord, exclusion of private banks in the FAQs. They don't use private banks for this channel because let it remain in one particular bank which can be trusted. And your lordships would not, my lord, kindly, my lord, bear with me, not trust institutions. And I'm going to show to your lordships that there is any deviation. If anyone tries to breach into the confidentiality, it leaves its footprints and will not go unpunished. My lord, I, as a law officer, spoke to the chairman of the State Bank of India. And I have his letter signed by him saying three things. A, except the contingency contemplated under section 7(4), that is the court's order, nobody can get. Well, I might even read, my lord, the later, my lord, so that your lordship conscience is satisfied that even ruling party will not know. Lord, if I can share, it's a 3-paragraph, 1-page later, my lord, just to satisfy your lordship's conscience that the scheme does not allow or permit even ruling party to know about, even the government to know about. The central government as a body, my lord, no, not forget the ruling party in the government. Central government would not know. Lord, I have the hard copy, my lord. I will. Yeah. Lord, this is a letter addressed to me. Or may I read? In response to the queries of the Solicitor General, we submit our response as under. The State Bank of India has a foolproof mechanism for maintaining complete secrecy of details of purchaser of the electoral bond and also the political party which deposits such electoral bond. This information cannot be shared with anyone, including the central government. In the eventuality contemplated under clause 7.4, there is a scientific system available whereby this confidentiality can be decoded by a process and be placed before the competent authority or court under clause 7.4 of the scheme. It will not be in the interest of the scheme to put it in public. The mechanism which will be used while decoding information for being provided as required under clause 7.4 of the scheme. Now, my lord, the largest public sector bank is before the highest court of the country, signed by the chairman of that bank saying that this cannot be shared even with the central government. And we have a mechanism in place that nobody can breach it.
Just one.
So, my lord, the point I am respectfully making is that we have to trust institutions that they will go by the law. My lord, if there is any deviation, I have a suggestion, my lord, which I'll make at an appropriate stage when I come to that part of the scheme. Now, my lord, C is issuing branch. Issuing branch means a designated branch of the authorized bank specified in Annexure 1 for issuing electoral bonds. Lord, everywhere it cannot be purchased and everywhere it cannot be deposited. Because, Lord, what happens is, Lord, why this? The donor and donee both must have a designated account in a designated branch. Why, my lord? I'll just very candidly and very bluntly point out, my lord, what can happen. My lord, I purchase a bond of 1 crore of rupees. I'm sorry, my lord, your lordship, sir. I purchase a bond of 1 crore of rupees. I give it to a political party. They don't wish to show it in their return at all. What they can do is, they can go to one small cooperative bank in Trichur or some corner of Gujarat or some corner of Lord Maharashtra, deposit it, withdraw in cash, and nobody would come to know. To avoid this, we have said that every political party will have one designated account. Only there it can be deposited, and that would be in one of the 29 designated branches. And it is so ensured that each branch is there in each state, broadly. Then, my lord, D. Person includes an individual, a Hindu undivided family, a company, a firm, association of persons, or body of individuals, whether incorporated or not, every artificial juridical person not falling within any of the preceding subclauses, and 7, any agency, office, or branch owned or controlled by such person. But petitioners have confined their arguments essentially to companies. But this includes all. And, my lord, there are several donors from experience, my lord, when I discuss, who donate on individual basis. Lord, there are several conventional businesses like transport business, like contractors business, where they are individuals who do the business. They don't form any kind of formal company or Hindu undivided family or a partnership firm. Then third, eligibility for purchase and encashment of electoral bond. The bond under this scheme may be purchased by a person who is a citizen of India or incorporated or established in India. Lord, I am keeping Lord FCR apart separately. That's not something which is argued. Your lordships have very consciously, my lord, by judicial order detected. A person being an individual can buy bonds either singly or jointly with other individuals. Only the political parties registered under section 29A of the Representation of People Act and secured not less than 1% of votes polled in the last general election to the House of People or Legislative Assembly, as the case may be, shall be eligible to receive the bond. The bond shall be encashed by an eligible political party only through a bank account with the authorized bank. There would be a designated account out of these 29 designated branches. Well, the objection was that why this 1% limit? And there is a simple reason. Earlier, when exemption was given to political parties, there were some mushrooming of political parties, fake parties, just to get exemption. Therefore, 1% presence would mean you are a serious political party, and 1% is not something unrealistically high. And it can be even in parliamentary election or in any of the assembly elections. So just to ensure that there are no fake parties which are created to get benefit of this. Then 4, applicability of know your customer norms. The extant instructions issued by Reserve Bank of India regarding know your customer norms of a bank's customer shall apply for buyers of the bonds. The authorized bank may call for any additional know your customer documents if it is deemed necessary. Now why this? Apart from the obvious reason that there cannot be any anonymous purchase. I cannot go and say that I will not give my name, but give me the electoral bond. There is a list of KYC documents. I'll have to give my Aadhaar number, I'll have to give my PAN number, I'll have to give my residential proof, I'll have to give my passport number, if any, etc., so that anyone cannot just walk in and purchase the bond. That is, the object. There is one more reason, and your lordship, as the highest court, must know about it. Therefore, I am saying, India is a signatory to one treaty, international treaty, that is for eradication of money laundering and drug money, under which there is that's Vienna and Palermo, there are two conventions, where there is one financial action task force. It's created under the aegis of the United Nations. That task force has created 40 conditions that every country who is a signatory will have to follow those conditions. Based upon every country's performance or compliance of those 40 conditions, there is a peer review. Other five persons from different countries would come and review our system, whether we are following that or not, and would grade us. We can be in white, what do they call? White list, grey list, black list, which decides whether in international market like World Bank, Asian Development Bank, India as a nation would get the financial assistance or not. If we are in the grey list, we will not. One of the major condition is that bring your clean money into the system, and one of the mode is to insist for KYC documents. Therefore, the neighboring country was in the grey list. It managed to come out of it. Otherwise, it was going into the blacklist. And that also depends, based upon the gradation. Gradation also decides our credit rating at the international stock market, the country's credit rating. Therefore, it's very crucial to follow those 40 principles. Then denomination. The bonds shall be issued in the denomination of 1,000, 10,000, 1 lakh, 10 lakh, and 1 crore. This is for the purpose of administrative simplicity. And, my lord, as your lordships, my lord, very rightly, my lord, expressed the concern that somebody can be aggregator. My lord, if I want to donate 50 lakhs, then 50 crores, then I'll have to find out 50 aggregators. Instead, it is easy for me to go and pay cash 50 crores, that this is my contribution. Why should I go to
No, the party does not get money in white.
a party?
Party wants capital.
Party does not need money in white. Let us be very clear. The government is insisting that every party.
This is not a scheme only for elections. It's not a scheme only for elections.
Correct, Manoj. It's for running the party. It's for running the party. No, I am not feeling shy of saying that, Manoj, because that's the part of the scheme.
It applies to everybody across the board.
Across the board, my learned friend said, "Ha," as if he trapped me into it. I am saying it consciously. Manoj, what happens is,
Well, I'm an independent member of parliament. I don't know why you associate me with the party.
yeah, let's
History can't
not go into it. Let's not go
victimize me. Don't victimize me by my history.
Is not entitled to get an electoral bond under the scheme. He doesn't have 1% of national or the local. Right.
Let's not go into it. A personal thing, I never, my lord, intended. My lord, what happens is, let me clarify that position. This is not for election. My lord, when we talk of election, we think of general parliamentary election. When a political party is running, but it contests parliamentary elections, it contests assembly elections, it contests local authorities elections, it has its own campaigns, it has its own rallies, it has its own think tanks. Think tanks are also, every party has think tanks, they have salaries, they need some kind of a building in every state. They need offices in every part of the country where the voters would go and seek some minor help, like my name is not entering into the ration card, etc., and some workers of the party, each party, so it's holistic, it's nobody has so far, heard, at least I have not heard, that as my learned friend gave a very fantastic example, that bungalows being built for the leaders. No party, I'm not on one party, has built bungalows for any leader. They are building offices and other electoral expenses. Now, comes to the validity of the bond. The bond shall be valid for 15 days from the date of issue. Again, nowadays,
I just consult, if you are not feeling too well, we can sit in one of our ante rooms and watch it on your iPad. We are now on streaming online.
I requested Mr. Sibal to sit in my chamber, and we have the video here.
You can ask the
I didn't want to say that.
I will have to reply. I should be here.
No, you can listen to the arguments.
If you would like to sit in one of our conference rooms, I can ask the registrar to.
Yeah, I can get done. I'll sit there. I'll sit there and watch if you're not.
In the morning, in fact, I suggested that it's nearer.
Yeah, I can do either.
No, you can go in by,
Just escort you, so you can take your iPad and
Mr. Sibbal, well, that's exactly what I told him when I
the
said,
moment he's here, we'll ask him to escort
well,
you.
my gesture was in
We realize the moment you get that.
that you go to my chamber, the video will be on. You can keep the video off and listen to the arguments. And
The work is, of course, part of our duties and daily lives, but
not at the cost of health, but that's what I.
बता दो, पुनीत को बता दो.
Now, my lord,
Off the track, the KYC with regard to anybody who makes donation above 2,000 rupees is also required to be done by the political parties, or is this format prescribed for that?
I just asked because in the scheme doesn't provide for.
This has nothing to do with the scheme.
I'll just, my lord, take instructions, my lord, and is for banking channels, yes, even if it is less than 2,000. But political parties can, there is no, the political parties.
When you take the name and other details, they don't take any document in support there.
Lord, as a matter of fact,
I'm just asking as a factual.
Lord, practically, my lord, let us
It's
speak.
not possible. It may practice.
Nobody pays, my lord, 1900 rupees or 19,000 earlier rupees, my lord, nobody comes. If I get as a political party 100 crores, I'll have fictitious names divided into whatever is the amount, and I'll show that so many people, so many thousand people gave me 1900.
There is no check as far as multiple deposits by same person is concerned.
So now that incentive is not. But if 1,000 is also electoral bond permitted. If I want to buy electoral bond of 1,000, it is through the KYC channel only. But if I want to go and give 1,000 rupees, which nobody would go and nobody would take, but then there is no KYC. Not anybody can go and take. Then, my lord, validity of bond. The bond shall be valid for 15 days from the date of issue, and no payment shall be made to any payee political party if the bond is deposited after the expiry of the validity period. The bond deposited by any political party to its account shall be credited on the same day. Look, this is one check, my lord. Can you see, my lord, why this 15 days period? A, it does not become a currency. It does not become like a bearer bond which can be traded. That is number one. Number two, Lord, this eliminates the element of a potential kickback. I'll tell your lordships how. Lord, I keep a electoral bond of say 100 crores with me. I tell a political party which is about to go in election that I have 100 crore. If you form the government and if you give me this contract or whatever is the quid pro quo, this is yours. If 15 days is to be mandated, this is not possible. I have to give it to them and take a chance. If there is a quid pro quo. I again say, all do not donate because of quid pro quo. Fortunately, we have that business atmosphere, that business environment.
What was the actual reason for putting this 15-day cap? I mean,
look, this was the reason. A, it doesn't become a trading currency that I owe 1 crore to my learned senior, my lord, learned attorney. I don't have, Lord, ready cash, which I can give it, or he doesn't want to accept cash or whatever. I can give him the bond. So bond is not a trading commodity, cannot be traded. Second, as my lord, I'll just, my lord, explain in a different way. Lord, let us give a live example so that, my lord, it can be better clarified by me. Madhya Pradesh is going in election. BJP can win, Congress can win, or any other party technically can win. I go to Congress with 100 crores worth of electoral bond. That this bond I have. if you form the government and give me this particular contract after you're forming the government, this will be yours. This would be quid pro quo, which is, my lord, completely minimized if I have to deposit in 15 days only. So I have to give it within 15 days, and they also cannot keep it pending till the government is either formed or not formed. They have to deposit. So I take that risk as a contractor of paying to a party which may or may not form the government. That is why this 15 days. But these are all checks and balances, whichever could be practically thought of, are incorporated. That it is not becoming another problem while we are trying to find a solution. Sometimes the solutions are bigger than problems. So therefore, while the Honorable Finance Minister, the then Finance Minister says that this may not be a foolproof scheme, but we have tried to make it as transparent as possible. No. And, my lord, it will be read with 12. If it is not deposited in 15 days, it goes in Prime Minister relief.
That yes.
So money you don't get back. The donor does not get back the money. It is for him to ensure that the party deposits. Otherwise, what happens is he is out of pocket for 1 crore or whatever crore. Party doesn't get it, so he doesn't get, if at all there is any quid pro quo, and his money goes in Prime Minister's relief. Therefore, my lord, this is, he will also have to say that, but you deposit this amount. Otherwise, my money will go to Prime Minister Relief Fund, not for the purpose I am giving you. So this is, my lord, a strict check, which is inbuilt. Yes, my lord.
And you have now seen the scheme. You have explained it.
Only 7, my lord. I have a suggestion. Therefore, my lord, another thing my learned attorney, my lord, very rightly says that this is not election-related bonds. Your lordships have seen every tranche is 4 times,
Right.
4 quarters of the
January,
account.
April, July, October.
So, my lord, I as a political party get 10 crores. I can't wait till the next election and promise him that if I get elected, I'll deposit and I'll give you something as a quick. If it is a contribution, it is a contribution. Within 15 days, you have to deposit. My lord, 7. My lord, which might, my lord, I'm going to make one suggestion, which might, my lord, perhaps substantially take care of your lordship's very valid concern.
Can you make the suggestion if we can just take it down and then we read it together?
Kindly have a look at, my lord, the 7 first.
Yes. Sir.
Procedure for making application for purchase of bonds. Every buyer desire of purchasing bond can apply with a physical or through online application in the format specified in Annexure 2, which provides for KYC, etc. Your lordships are right now not concerned. Every application shall contain particulars. Your lordships can leave it. On receipt of an application, the issuing branch shall issue the requisite bond if all the requirements are fulfilled. Now, 4 is important, where, my lord, the Chief Justice had some concern, and my lord, Justice Khanna also had some concern. And I'll, my lord, very candidly express that concern and, my lord, satisfy your lordships. 4.
Yes.
The information furnished by the buyer shall be treated confidential by the authorized bank. First part. This is the mandate of the scheme. Correct, my lords?
Yes.
And shall not be disclosed to any authority for any purposes except when demanded by a competent court, to which, my lord, no one can have any objection. We have to trust the court ultimately. Or upon registration of criminal case by any law enforcement agency. My lord, there are 2 things which may, my lord, perhaps not be acceptable to your lordship's conscience. A, what happens if this confidentiality, which is statutorily built in the scheme, is not adhered to?
Yes.
But your lordships would mark that if I try to breach the confidentiality system, it would lead digital footprints left. It's not, my lord, as if my learned friends were it's not even oversimplification, something less than that, that you can just see in the light and you get the number and you can compare it with the political party. It's not like that. If necessary, my lord, I'll come to that. My lord, what is the system? It leaves its footprints in the digital format which cannot be erased. Please read and kindly see, my lord, the intention of the government and, my lord, the bona fides of the government. Anyone not complying with or committing breach of this confidentiality, your lordships may say, would be criminally liable for criminal breach of trust. Or whichever other provision, my lord, which is applicable. I have not examined, my lord, from IPC point of view.
Yes.
Correct, my lord? So this takes care of one thing, that you have the biggest public sector bank, the assurance of the chairman of biggest public sector bank, with your lordship's direction that any breach will be visited with penal consequences. Now, my lord, second, and that's where my lord Justice Khanna's very valid concern, my lord, was expressed. So far as court is concerned, my lord, I don't think anybody has disputed. My lord, somebody were to go to the court. My lord, for example, just to answer my lord Justice, Chief Justice's query, that there is a quid pro quo. Suppose somebody goes to the court that this gentleman has given money as per his bank statement or as per his account, or this company has given 50 crores to some political party as per his statement. Kindly listen to this. This is interesting, my lord, how the scheme works. That this company has given 50 crores to some political party, that is reflected in their balance sheet, which is to be made public as per the company's law. Immediately thereafter, the one particular government has given him a contract worth 250 crores, and therefore I suspect he has to give reasons. He can't rush the way PIL petitioners are rushing, but he can say that there may be a quid pro quo, and the court is prima facie satisfied that yes, there may be. Let us see whether those 50 crores has gone to the party which is in the government who has given the contract. That is why under the court's order, it will have to be decoded, which has a very serious and complicated process. It is not easy even under the court's order. Now, the concern of my Lord Justice Khanna, and very right concern, that upon registration of a criminal case by the law enforcing agency, my Lord, the concern would be that you register a criminal case and ask SBI that give me the details. That was, my Lord, the concern. Your lordships would recall in Aadhaar judgment, there was a similar provision. And your lordships have read it down to me to say that when investigating agency wants this, it can get only if there is an order of the court. Kindly put that layer by reading it down.
Yes.
Look, kindly see, my lord, the bona fide is, the purpose is not that the party in power knows what is paid to whom. The purpose is not that this is to be used for the purpose of penal persecution.
Yes.
So, my lord, level playing field, when we talk about the level playing field, my lord, if I have to understand level playing field means every party should get equal political contribution, that can never happen. Mr. Sibal would have 10 matters, somebody would have only one matter. Nobody can argue that there should be level playing field, everyone should have 3 matters. That every political party will have to rise to the level that they get more trust and they get more contribution. But if the level playing field argument is attached to the fact that the party in power comes to know about it, well, this is the way in which it can be taken care of, and both apprehension and the public interest can be balanced. That even party in power will not come to know. Now, my lord, at this stage, my lord, I would like to show how, my lord, this scheme operates to satisfy your lordship's conscience. Because yesterday I found, my lord, your lordship's valid concern that it is possible for the ruling party to know, but the rest of the parties would not know. My lord, as I was told by the chairman, that it can't be discussed publicly. Whatever can be discussed publicly, my lord, I have a separate thing. On my request, the officials of the SBI are here. Lord, I would request your lordships, if your lordship would like to know the entire semantics, how this system operates and how there are separate silos which cannot be breached, and you have to go into one system, you have to go into another digital system, you have to go into third digital system, leaving your footprints. If there is a court order also, then your lordship would be satisfied that it's not as if that a finance secretary calls the managing director of SBI कि हर 15 दिन मुझे भेज दो किसने कितनी कौन सी पार्टी को कितने पैसे दिए. It's impossible. It's that foolproof a system. Your lordships can hear them in chamber. But right now, my lord, I may show this, my lord, what is the system to satisfy your lordship's conscience. It's not, my lord, as if that I go and deposit some amount in the bank and tomorrow the senior official of the bank calls the branch manager, what amount Tushar Mehta has deposited. He will just see and say that he has deposited 10,000 rupees. It's not that simple. It cannot be that simple. When we are ensuring confidentiality and when confidentiality is the heart and soul of the scheme. Please, my lord, allow me to share this, my lord, screen share this. My lord, there are extra copies also. I have emailed also. But I have not, my lord, I have missed purposefully. I have decided, it's my, my lord, call that I have not said many things which the chairman also rightly feels and I also feel should not be made public. What is, how we maintain secrecy, my lord, can't be a public debate. That's all. Because by definition, it has to be confidential.
Mr. Solicitor, just so that we have a little bit of an eye on the clock, learned attorney will take about half an hour after your turn.
I think so, my lord. I might be over by 1.
1 o'clock if you 1 o'clock if you finish.
I will.
So learned attorney can then argue between 2 and 2:30.
Correct.
And then we can leave a little time for
I can rest assured, I can, my lord, assure your lordships that every judgment which I have quoted, I'm not going to cite. I would be very naive if I quote judgments which I know your lordships
give
have
us
read.
the citation and the paragraph so that
I have quoted that.
oh, I see. In your
So I'll say that kindly read it. I'm not going to read except few judgments which I'm unable to resist that.
you may just flag those. That's all for us.
Yes. Lord, this is, my lord, the copy is given.
Leave yourself a little time to deal with the challenges to the amendments to the statutes. Huh?
These are, my lord, the objects.
Right. We have now covered the scheme.
No,
I'm just saying that since you have an hour to conclude, give yourself a little time to deal with the challenge to the statutory amendments.
that's what, my lord, my answer is, one-line answer. The statutory amendments are to ensure that this scheme can be framed and can be operated. That's the purpose of the amendment. There are no separate objects.
That's okay. And you have really covered the reasonableness aspect as well.
There are corollary.
Yes.
To, my lord, the scheme. First, it came under the Reserve Bank of India Act that government can formulate the scheme. That is challenge to the Reserve Bank of India Act. My lord, now by itself is not illegal.
Just wanted to ask you this. It may not be very relevant but just to understand the legal framework. Why was it necessary to amend the RBI Act actually to bring in the scheme? I mean, as a matter of law, what was the reason?
Lord,
we just have that. I have, in fact, it opened here at page 31 in your written submissions. Section 31 says that no person except the Reserve Bank of India or the central government can issue a bill of exchange, promissory note, or engagement for the payment of money payable to bearer on demand.
Well, it would be a bearer bond, my lord, because
The reason seems to be, and that's RBI's report, that only central government and RBI is permitted under that section. The issuance is being done by SBI now. So
no, that's not the
Yes,
idea.
so it's somebody else which is being permitted, and that's one of the reasons which the RBI's letter also, which I think Mr. Bhushan showed to you.
Lord, there is nothing turns on the, and you will not succeed or lose on this. But, my lord, the purpose was,
31 mein hai wo. 31.
please see, my lord, one, this was to make an exception to one.
That there's an authority or the legal
There
power
is a
to issue this.
statutory backing to
Statutory.
the scheme. That's
Want to
the,
be confronted with a legal
That
challenge.
is a purely executive act. minus,
yes, otherwise it would have been challenged as an
the
executive act.
legislative backing.
It could have been said that it's a bearer bond, only the RBI can issue, etc., etc. And therefore, my lord, with a view to empower the central government to come out with this policy.
And it would otherwise fall within the broad definition of a bill of exchange.
Exactly. Or a bearer, my lord, instrument. They say payment of money payable to bearer on demand to borrow.
Or engagement for the payment of money payable to bearer on demand. Engagement is very broad.
And one,
Therefore, that
my lord, subsection
three-
1, first line,
Yes.
subsection 1, no person in India other than the bank, that is RBI, or as expressly authorized by this act. So this is the authority given to the central government. That's all, but to give a statutory backing so that it doesn't remain an administrative instrument.
All right. Now what next, Mr. Solicitor?
Yes, my lord. My lord, now what I'm reading is on the screen, my lord. I have shared, my lord. My lord, your lordships may skip 1 Roman 1, 1 Roman 2. Gautam. अच्छी बात.
To read this out.
Or 1 and 2, Roman 1 and 2. I've said, nothing to hide, my lord. I've said that the chairman has, my lord, one should trust the system, etc. my lord. Third, without elaborating, however, a brief description of the system can be provided to the court to satisfy the court's conscience that it is impossible for anyone, including the incumbent government, to breach this system without A, the contingency contemplated under clause 7(4), or B, without leaving a digital footprint and trail if someone tries to breach into the system over and beyond the mandate of clause 7(4). The process for providing donations through electoral bond has two separate compartments, and they are issuance of bond and redemption of bond. Correct, my lord? Your lordship knows. I leave it at 3. In order to maintain confidentiality of the process, the data that is populated at both ends is recorded in a limited manner and not populated in the central databases. It doesn't contain the name of the donor. My lord, I can purchase it from Assam, Guwahati, because that is one of the SBI branches, and pay in Delhi to Indian National Congress or Bharatiya Janata Party because their office is situated here. They can have their authorized account practically, generally in Delhi, but anywhere in the country. And I can purchase it from Delhi and pay to Trinamool Congress in Calcutta. They would have their account in Calcutta. Now 4, separate storage and separate collection of data ensures that there are no direct linkages maintained in the database between the donor details with donee details. 5, The register which is maintained at the designated branch, please mark this, which issues the bond does not maintain the register with names of the purchaser or the donor. So if I go and buy a bond worth 1 crore, the register would only say one bond issued, 1 crore rupees. My name will not come. The only person, my lord, I must, my lord, tell your lordships, which would temporarily come to know would be the cashier, my lord, when I go with my KYC documents. Because,
The issuing bank.
yes, the one person.
11.1 says, all payments for the issuance of the bond shall be accepted in Indian rupees through demand draft or check or through electronic clearing system or direct debit to the buyer's account.
Yes, so it will
payment
have to
made
be through
check or
banking
draft
channel.
shall
No,
be
the
drawn in
purpose
favor
is
of the
this.
issuing bank, and therefore the issuing bank has all the data.
No, it would come, my lord. Therefore, it would come. The only person who would first know my name and is the person to whom I give KYC. Then KYC is sealed cover is maintained elsewhere. But it comes. The details of donor, i.e. the KYC details are put in a sealed at the end of each tranche, because within 15 days, many people purchases many multiple bonds. But I may purchase 10 bonds worth 10 lakhs of rupees. Tranches by the designated branch and sent in a sealed covered form to the SBI main branch, Mumbai main branch, where it remains sealed till the contingency under clause 7(4) arises. So Guwahati, where purchases are made, or Trivandrum, where purchases are made, will send it in a sealed form to Bombay. So far as the redemption of these bonds by the political parties is concerned, each party can deposit such bond only in their designated account. In account details of the political party also, only the amount of the bond will be reflected, as the bond does not contain the name of either purchaser, donor, or the political party. The political parties would have one designated account in one branch out of the designated branches of SBI, in which only the redemption of electoral bond is permissible. So bond may have been purchased, my lord, from Chennai, but will be redeemed or can be redeemed in Calcutta. However, the political party can present the bond for redemption in any of the designated branches, which will credit the amount only in the main designated branch. They can go to Jaipur and say that this is my bond. The money would be transferred without anybody's name to the designated account wherever it is maintained, one designated account. At the time of redemption, the original bond, the pay-in slip would be storage in a sealed cover and sent to SBI Mumbai main branch. Both the sealed covers cannot be opened either together or at different times, except under the contingency under clause 7(4) arises. In the event of contingency under clause 7(4) arising, it would be very difficult to trace out that even after that, my lord. Kindly see this. It's not as if we open the cover and match it. Trace out the details of the purchaser of the bond, as such purchaser may have purchased several bonds from several designated branches in different tranches. In other words, several sealed covers may have to be opened and examined. 2. So far as details of redemption details are concerned, they are stored in the Global Information Technology Center of SBI, which stores the data in a digital format. In case the link between the donee and the donor is required to be established in terms of clause 7(4), it would require a detailed and in-depth tracing out of information from two different information silos of donors and donees. The said exercise is not automated and cannot be carried out in a linear fashion and requires a scanning of different databases which are designed without maintaining interlinkages. Therefore, the process of issuance and redemption of electoral bond and data generated therewith is not maintained in a central database, and the data sheets are not populated and tallied at one end. There exists no direct linkages, and completely separate information silos are stored under separate heads with separate departments. So I'll have to ask several people to collude with me if I want to get the information. Because, Lord, I have not given that, but this center, Lord, Global Information Technology Center also, as I was, Lord, explained, I was also not explained in detail, and nor did I insist. But they also have 3-4 layers. It goes, the request with the court order goes to one, he will open, then it goes at a second layer, then he opens, and everything is digitized, leaving the footprints. And therefore, my lord, to satisfy your lordship's conscience, I say that please criminalize if there is anybody who breaches this system.
Yes.
Yes. Now, Lord, I'll come to, my lord. Please come to page 36 of my written submissions. Rather, my lord, I would, my lord, at page 37, my lord, I have quoted Puttu Swami. And, my lord, I'll abide by the time, my lord, your lordships have indicated. But your lordships would, my lord, bear with me. I have not repeated, my lord, except.
No, not at all.
Lord, I'm not reading this Puttu Swami, my lord. Your lordships, all of my lords have read and read it. But the purpose, I'll say, Lord, your lordships have devised this concept of informational privacy. Lord, your lordships were examining two competing interests, namely, one, right to know, and second, right to have informational privacy. And your lordships have accepted information privacy to be a fundamental right. If, my lord, I am the person donating, and if your lordship's conscience is satisfied that system is in public interest, your lordships can, Lord, accept my right to informational privacy as against general right to know. And why, my lord, I say this? If there is a genuine public interest in the disclosure, you go to the court, you have 7 for remedy. But merely for your curiosity, you cannot invade somebody's privacy if that privacy ultimately serves larger public interests. Lord, that's the submission which I have made. My lord, I have quoted the relevant paragraph. I'm not, my lord, reading it. Your lordships are aware. Lord, please come to. You are saying that you are Come to page, I'm sorry,
Yes.
page 39. I'm just skipping through, my lord, rest.
Yes.
My lord, not that I'm giving up, my lord, maybe treated as read.
Yes.
Para 95. In the matter of Puttuswamy, this honorable Justice, it should be Justice Puttuswamy, this honorable court discussed the validity of section 33 of the Aadhaar Act, which provided for disclosure of information including identity. I'm sorry. Lord, I was on 95 reading Puttuswamy, second para, 95 second para. It is submitted that while upholding section 33, this honorable court, however, added a layer of safeguard as per which such information may be shared only upon an order being passed by the judge of a high court. Now, your lordships respected the privacy, but in public interest, if lordship says that if it is required, then of course with the order of the high court. So it's not, my lord, as if it's an afterthought which I'm suggesting to your lordships. It's already there in my written submissions, which shows, my lord, that the intention is not that there is no level playing field. Government, whichever is the party in power, knows about it, and the rest of them do not know. Nobody should know. That incentivizes clean money coming into the system. Then your lordships, my lord, kindly skip the rest and, my lord, come to, my lord, I have quoted, my lord, FAQs which are relevant, my lord, but broadly I have indicated, my lord, what are those, my lord, FAQs. Please come to, my lord, page 46, Lord, 46. But this I have already argued. I will not, my lord, bother your lordships. Please come to page 48. Lord, here, my lord, I would respectfully seek permission to read only few paragraphs of the judgments, my lord, because your lordships had a valid concern that in some cases it can be quid pro quo, in some cases it can be misused also. Lord,
Yes.
nobody says that it cannot be. Any system can be misused. There can never be a system which is so foolproof which can never be misused.
You are reading the Shirur Math case?
Yes, my lord. Lakshmindra Tirth, my lord, the Shirur Math, my lord. Kindly see the last three lines which are bold and highlighted, my lord. For your lordship's convenience, my lord, I have done this. I don't wish to read the whole. The saving provision contained in section 91 of the Act makes the position quite clear. An apprehension that powers conferred by this section may be abused in individual cases does not make the provision itself bad or invalid in law. Now, this is, your lordships are aware, my lord, 7 judges case. 7 judges judgment. It can, my lord, in Indian ingenuity is, my lord, popular around the globe. And general human ingenuity, my lord, everywhere this is happening. Then, my lord, please see 117. Similarly, in collector of customs versus so-and-so, this court observed the possibility of abuse of a statute otherwise valid does not import to it an element of invalidity. Further, in state of Rajasthan, it was said that it must be remembered. Well, these are very well put, therefore I am tempted to read. It must be remembered that merely because power may sometimes be abused, it is no ground for denying the exercise of power. The wisdom of man has not yet been able to conceive of a government with power sufficient to answer all its legitimate needs and at the same time incapable of mischief. There can never be a system. We have started, we have begun, and as I pointed out, the beginning is giving us fruits. Digitized money, my lord, is bringing clean money into the system. I have given the figures, my lord, of payment made by digital mode. Then, my lord, Keshavanand Bharti, in exercising the power of judicial review, the courts cannot be oblivious of practical needs of the government. The door has to be left open for trial and error. Constitutional law, like other mortal contrivances, has to take some chances. Opportunity must be allowed for vindicating reasonable belief by experience. Lord, the government, which consists of all politicians, the parliament consisting of all people in politics, my Lord, they discussed this threadbare and found that there may be some lacunas in the system, but this is under the circumstances the best system. My Lord, that trial and error, my Lord, the government is entitled to. My Lord, then, my Lord, I am not reading Mafatlal, but please, my Lord, come to, my Lord, I am not reading A.K. Roy also, please treat it as read. Please come to PUCL. Lord, PUCL also, my Lord, is on the same lines, my Lord, therefore there is no point in duplicating, my Lord. Then, my Lord, I have pointed out right, my Lord, legitimate state interest. Lord, your lordships would always balance. I have argued this, my Lord, I will not take your lordship's time further. But the legitimate state interest is linked to public interest. So you have the right to information, no denial, but you have the information which company purchased how many bonds, and you have the information in public domain which party got how many electoral bonds. If anything beyond that is encouraging cash, Lord, economy to enhance, Lord, that your lordships can balance, and that would be in the legitimate state's interest. That public interest would be of paramount consideration when your lordships examine this, my Lord. Lord, please see para 130. It is submitted that specific judgment in PUCL and SO, my Lord, which were referred to by them, sought disclosure of information which was already in the knowledge and possession of the state authorities. When they say that you declare what is your property, you declare what are the criminal proceedings, these are all in public domain. At once platform you declare, but here you are trying to lift the veil of confidentiality, which is by design made a part of the very system and which is the pivotal part of that system. And even the government doesn't know it. So, my Lord, right to information cannot be claimed from me. Now, your lordships may, my Lord, kindly go to Lord, Lord, page 60, Lord, one passage from Puttaswamy. This is the majority view, my Lord. Of course, my Lord, all views are concurring except on the ground of, except the question of money bill. Privacy, your lordship gets that? Privacy and proportionality are two interlocking themes that recur consistently in the above judgments. Privacy, also construed as informational self-determination, is a fundamental value. There is a consistent emphasis on the impact on personal dignity if private information is widely available and individuals are not able to decide upon its disclosure and use. This right of controlling the extent of the availability and use of one personal data is seen as a building block of data protection, especially in an environment where the state of technology facilitates ease of collection, analysis, and dissemination of information. Then your lordships may, my Lord, kindly see how, my Lord, the judgments cited are different. My Lord, I have already said.
Yes.
My Lord, level playing field, my Lord, I have dealt with at page 64. But, my Lord, I have already, my Lord, orally made submissions before your lordships, my Lord. But kindly see, my Lord, 151, para 151 at page 65. I have already marked, my Lord, which portion I'll skip and which portion I think I must assist your lordship with. 151. The petitioner claims that there is an incumbent bias as large amount of money go to the ruling party. It is submitted that whether such an incumbent bias exists, and if it does, what its extent would be is a question wholly irrelevant to determining the constitutionality of the scheme. And my lord, I have already said that that has been the trend. The ruling party gets maximum because ruling party has the confidence of the maximum people. Yes. Now, my lord, page 65 bottom. My lord, I have said that secrecy per se is not alien concept in even electoral issues. Secrecy of ballot.
That's something separate. In the uneven level playing field, you've referred to fairness of elections. That issue is not being addressed.
Correct.
Has that issue with regard to fairness in elections been, or because of the mismatch between the money part, has that been addressed here? Because that may be a larger picture, not specific, like alone to.
I'll just, my lord, again, my lord, try and attempt to point
No,
out.
you have argued that because of ruling party has always been getting substantially more donations.
Lord, average Indian voter, be it corporate or an illiterate voter, my lord, we have to accept this fact. And we should be proud of that fact. He is a very intelligent decision maker. A ruling party in 2013, though ruling party may not get maximum my lord, political contribution, because the voter knows that in 2014, the wind is somewhere else. We have to trust his discretion. So ruling party is not getting maximum because of the scheme. That's my submission. My lord,
According to even otherwise, the ruling party would get.
always, Lord, even before this scheme, I have shown from 2005 to 2014, whoever was ruling party, Lord, BJD is a ruling party in one state of Odisha. They have maximum, Lord, political contribution. That's the trend. That's how the people of India contribute. It's not as if because of the scheme, the ruling party is getting any benefit and there is no level playing field.
Yes.
My lord, I have analyzed, my lord, in secret ballot, that secrecy per se is not antithetical to free and fair elections. Sometimes it enhances free and fair elections. Like, my lord, in my respectful submission, the present case. Lord, kindly come to, my lord, page 70, para 165. Where I have, my lord, attempted to address how, my lord, this scheme accelerates or enhances free and fair election, my lord. It is submitted that your lordships have, my lord, para 165, my lord Justice Padiwala.
Yes.
It is submitted that a conjoint reading of the principles of secret ballot and the right to privacy under Article 21 clearly postulates that there exists a claim on part of the donors to make donations without fear of reprisal. It is submitted that such right would obviously not be absolute and would have to be counterbalanced with public interest and concept of free and fair elections, and further optimized with policy interest of bringing the first step of shift from cash to banking channel in political donations. It is submitted that the balancing element in the present policy is clause 7(4) of the electoral bond scheme, clearly provides for disclosure in case of appropriate proceedings before the competent court or criminal proceedings. Lord, then I'll not, Lord, bother your lordships further. Lord, then kindly come to page 73. Lord, financial policy and limits of judicial review. Lord, I am not going to read the whole. I'll just read the highlighted part because that would, my lord, in the facts of the case, be very, very relevant and direct for assisting your lordships. Lord, first is Rustam Kawasji Cooper. Your lordships, Lord, know the judgment. Lord, it's a bank nationalization case.
Then Garg is the bearer bonds.
Yes, my lord, 63. My lord, would your lordships like me to skip, my lord, Kawasji Cooper, my lord?
Absolutely. You can just show us the title of the
Yes.
case and then we'll
Yes.
read it now. No.
Then my
All
lord,
old,
in
well
R.K.
said,
Garg, I would like to read, my lord, few paragraphs which are not quoted. Kindly go to, my lord, page 2175. I'm sorry, my lord, there is a mistake in volume 2, 2184, my lord. Allow me to read, my lord, only few paragraphs.
Same volume.
Volume 2, my lord, main volume. 2184. There.
Yes.
Lord, please read
So
para
what- which
16 and 17, my lord, at page 2194, my lord. Para 16. My lord, here also it was concerned with the black money part. Therefore, my lord, I am tempted to read 16. Your lordship gets, my lord, page 1924, my lord. 2194, sorry. 2194. It was then urged, your lordship gets, my lord.
Yeah.
It was then urged on behalf of the petitioners that section 4, clause C operates only in relation to a period.
That is,
I'm sorry, para 16.
that's 2203.
203.
2203.
I'm sorry. Your lordship, I'm giving wrong pagination because there are two paginations. 2203.
2203 is the PDF.
My apologies, I stand corrected. I'm obliged to my Lord Justice Party. It was then urged on behalf of the petitioners that my Lord Justice Gawai got that section 4, clause C operates only in relation to a period before the date of maturity of special bearer bonds, and after the date of maturity, the holder of special bearer bonds can sell such bonds and without running any risk disclose the consideration received by him as his white money, because section 4, clause C being out of the way, he can account for the possession of such money by showing that he has received it as a consideration for sale of special bearer bonds. And so far as the purchaser is concerned, if he has paid the consideration out of his black money, he can claim the immunity granted under clause 3. Thus, the black money of the seller, which had been converted into white on his subscribing to or otherwise acquiring special bearer bonds, would remain white, and in addition, the black money of the purchaser would also be converted into white by reason of his purchase of special bearer bonds. This argument, plausible though it may seem, is in our opinion fallacious and cannot be sustained. It is highly debatable issue whether, under the provisions of the Act, special bearer bonds are at all intended to be transferable after the date of maturity. Here, my lord, 15 days. Here, their maturity was long period. For the postulate of the legislation clearly seems to be that on the date of maturity, the special bearer bond will be encashed. It is indeed difficult to believe that anyone holding special bearer bonds would keep them uncashed without earning any interest from and after the date of maturity, when they can be immediately encashed and the amount received can be invested, yielding interest ranging between 18% to 40%. Moreover, special bearer bonds would cease to be exempt from wealth tax from and after the date of maturity, and they would therefore be includable in the net wealth. My lord, last line of this paragraph, my lord, But the law cannot be condemned as invalid on the ground that after a period of 10 years, it may lend itself to some possible abuse. Lord, please come to para 19. Lord, the argument that black money would be promoted is dealt with, my lord. Lord, please read, my lord, para 19, my lord. It's a long para. I don't propose, my lord, your lordship's time. But it's the similar argument that you are encouraging black economy. The court, my lord, analyzed the entire scheme and said that no, it brings the clean money into the system. Now, my lord, coming back to my written submissions, my lord. Lord, please come to para 78. My lords are aware, but I am always tempted, my lord, to show these judgments, my lord. The Lochner era, my lord, which is known as Lochner era, where the Honorable American Supreme Court was having 7 honorable judges, and whenever there was a economic policy change by the president, it used to be struck down with the majority of 4 versus 1. And popularly, the 4 were known as 4 horsemen, and less known fact is 3 were known as 3 musketeers. That in America this is possible, but be that as it may. No, I'm sorry, 9, but one was being convinced by Justice McReynolds. So it is believed that he used to convince. But let's not go into it. Lord, this is Lochner versus New York, ultimately Lord, overruled. But Lord, your lordships would recall, Lochner versus overruled starts with a dissent by Lord Justice Brandeis.
Justice Holmes as well.
First by Holmes, thereafter Justice Brandeis, and thereafter that popular article written by Justice Brandeis on privacy in Harvard Law Review. And eventually, my lord, this was the Lochner was, my lord, declared, my lord, not to be a good law, my lord. That also I have, my lord.
All right, we can skip.
But, my lord, it says the government or the legislature, not the government, the legislature has a right of trial and error. No, this is accepted by our court recently, my lord, reasonably recently, when IBC was challenged. But there were several issues in IBC. There were several lacunas pointed out in IBC. But the court said that free play in the joints will have to be given. Even trial and error, unless it is so abhorrently or atrociously arbitrary that it can never satisfy our conscience, the court would defer to the wisdom of the legislative action.
Even in demonetization, we are also.
I have, my lord, relied upon that, my lords. Please see, my lord, at where is the judgment? I've just, my lord, we have quoted that judgment, my lord, your lordship's judgment in demonetization. But I'll just, my lord, give that site. Well, but the pagination, Lord, I have not marked, but I'm relying upon that.
Vivek Narayan Sharma.
Pardon, Lord?
Vivek Narayan Sharma.
Vivek Narayan Sharma, Lord. Lord, page 76, Lord, I'm sorry. Page 76, Lord. Lord, it is page 76, my lord. Vivek Narayan Sharma versus Union of India. Your lordships would find it at it's 2023 SCC online, page 1, where my lord also accepted, my lord, this proposition that government can have trial and error unless it is ill-intended, so atrociously arbitrary that it shakes your lordship's conscience, or it doesn't achieve the object it seeks to be achieved, or it is for a different object. But suppose the object would have been that the government of the day, the ruling party, would like to know who paid what to whom. Lord, I have therefore, my lord, satisfied your lordships that please criminalize if there is any breach of confidentiality.
Anything else now, Mr.
My lord, your lords, my lord, one of the questions, my lord, only 5 minutes, my lord, was what happened after the scheme was introduced? What is the trend, my lord? My lord, that we have given, my lord, in document number 2A, which, my lord, we highlighted yesterday.
Full compilation of documents.
सिक्स इज प्री डिमांड सिचुएशन इसमें देखेंगे वॉलंटरी
My lord, these are figures, and my learned colleague, my lord, has examined these figures. If your lordships can give him 5 minutes to explain what is post-scheme situation, my lords.
Okay.
My lord, that he would be able to do it better, my lord. I am never good at figures, and my lord.
2A, no?
Please, my lords, it is the compilation that is on the screen right now.
Yes.
If my lords would come to PDF page 8 of that compilation, it would show the party-wise income from unknown sources. This is a report by the ADR itself for financial year 17-18. So this is the pre-electoral bond scenario. In the first table, on the left-hand side column is the name of the political parties. The second column
What page is that?
is page number 6 at the top, but I believe the PDF page would be page 8.
It's page 6 only.
At the top right-hand side, the page numbering is page number 6.
Volume 2A, right? Compilation documents?
Yes.
Please, ma'am.
Page 8.
Yes.
Please, my lords. So Annexure 1, party-wise income from unknown sources, financial year 17-18. The first table has on the left-hand side column the name of the political parties. The second column, now this is the pre-electoral bond scenario because 17-18. Second column has the voluntary contributions below 20,000. I believe the Solicitor General has already explained that how this below 20,000 rupees mechanism was previously a sort of a loophole where contributions could come in without there being any identification. So this shows that how the first party has received about 342 crores in this financial year.
Yeah.
The third political party has received about 36 crores in this financial year. And the numbers go on. In the second annexure, my lords, if my lords sees the third political party, the total income from unknown sources is 39 crores. That contributes to about 37% of the total income. Now, my lords will see a trend which starts from 2018 onwards, that these contributions below 20,000, which if, for the lack of a better word, I can term as sort of slightly dubious contributions, have gone down. And simultaneously, the contributions by the electoral bonds have gone up.
2018, there was an amendment.
Please, madam, 2018, the bonds come in.
1 minute, please. Bonds is one thing, but the cash amount which would be deposited had come down to 2,000 rupees.
My lords,
Is
I
that
believe
correct?
No, my lords, the 29C amendment keeps it still at 20,000.
29C amendment, but cash deposits were restricted to 2,000 rupees. Is it correct?
No, Manoj, the declaration requirement is in 29C itself. So that amount remains 20,000. So still till date, less than 20,000 rupees can be deposited without it.
Till 20,000, above 2,000, you had to declare your identity?
Above 20,000.
Oh, that was retained, but
That-
cash deposits were restricted to 2,000 after the amendment in 2017. When was the amendment with regard to 2,000 rupees?
No, Manoj, there is no specific amendment with regard to 2,000 rupees.
There is no specific
Because
amendment.
The amendment on 2000 is in section 13A of the Income Tax
Income
Act.
Tax
What it does is that up to above 2000, if you pay by non-cash means, then you won't get the exemption under 13A of the Income Tax
It has
Act.
nothing to
But
do
the
with the
disclosure for 29C remains 20,000. That's right.
That 29C
Remains as it is to that extent. Manoj, the next year, that is
no, but
2018
that
and
may be reflected because of the amendment in the Income Tax Act.
Manoj, they may not want to take the exemption also.
No, nobody. I'm yet to see a political party which will say, so once the restriction under the Income Tax Act 13A is made 2,000, the immediate impact thereof is that the figures which will be disclosed will below 20,000 will come down.
As at the same time, Manoj, because there is another mechanism of electoral bonds, that figure has gone up.
Then show us how many deposits were made through electoral bonds of less than 20,000.
Manoj, may come to page number 13. There is something.
If that is so, then it will be reflected in deposits of less than 20,000.
There is something else also that comes out from it. The political party that has taken a principled stand of not accepting electoral bonds is still accepting those less than 20,000 rupees voluntary contributions. My lord, may come to page number 13, which is the physical page number.
CPM is
Please, my
accepting. Yes.
Page number 13, it may be page number 15 in the PDF.
Do we have the breakup of the bonds less than 20,000 and above 20,000? No.
My lords, I don't think so.
Because all are, because 1000 is the smallest denomination.
I'm aware of.
Because all of them are without any disclosure
Any
requirement. So that works across the bar for the electoral bonds.
Anything else?
My lords, this is the point. If my lords wishes, I can take my lords through
No,
the
we've seen
number.
that, page 13.
The numbers of electoral bonds will increase. The numbers of voluntary contributions less than 20,000, which are the dubious transactions, will decrease. The only political party for which it has not decreased is the political party that has taken the stand that it will not take the electoral bonds. So obviously that is a political party that is continuing in the older regime.
What is the ratio of the increase in non-bond deposits?
Well, the non-bond deposits have
Or
gone
through-
down.
No, non-bond deposits. If we exclude the bank transactions, what is the ratio in that?
Well, the bank transactions have remained the same. If my lords comes to page number 13, and if I would show the latest
Non-electoral, not bank transaction.
non-electoral bond plan.
So you can pay by check also.
Correct.
My lords may see the latest numbers at page number 40. It would show that the first party has received about, page number 40 would be 40.
This is the ADR report.
One chart and give it. What we can do is, well, by tomorrow, not for arguments, we can compile this, well, we understand. well,
I have note of 2 pages or so.
Not a note.
Just a
and
compilation.
chart.
Correct.
A
A
chart.
chart actually, a tabulation you can give us.
Yes, that
All
will
right.
be.
Thank you. Where is Mr. Amit Sharma?
He's maintaining his confidentiality. It's on the lighter side.
All right, we can start with the learned attorney, then we can hear Mr. Amit Sharma at the end.
Yes. Easy.
Mr. Attorney, then?
Election. He's not there.
He's not here. Please, your lordships. One is conscious
Yes, Mr.
With the global canvas on election funding, party funding, campaign funding is like a kaleidoscope. I mean, it presents very interesting items, experiments made, and just as the learned solicitor were talking about experimentation. And he has referred to one of the most oft-quoted judgments in US, the New York Ice Company versus Lehman Brothers. Experimentations in economics and related branches to stay experimentation. The court looked at it with a distaste. So if you look at all these experiments and how they have either invited a wide range of concerns. Now, I would address your lordships on 3 or 4 important aspects of the constitutional issues raised in this case. Before I do that, a very broad brush has been stated in this case. It is said that the scheme violates Article 14, 19, 21, and also undermines the basic structure of the Constitution. I think we need to take stock of this kind of propositions very closely. Alongside, it also said, well, here is a manifest arbitrary, and therefore Article 14 is attracted. I suppose that we must pay very close attention to an argument because a constitution bench, in terms of Article 145, looks at substantial issues of interpretation of provisions of the Constitution. Except when a reference is made on a difference between different benches. So the substantial questions of interpretation of the Constitution, there has to be something very precise, direct, and not too overbroad statements, which may resemble a political debate. I understand that a good part of the arguments made come closer to a political debate rather than precise statement of infringement of any particular constitutional right. Why I say that is placing reliance on 2 judgments of your lordships in the Association of Democratic Reforms and the PCL case that for the purpose of expressing your choice of a candidate, and you need to know the criminal antecedents of a candidate, a specific issue on hand, and a concrete right to be exercised, the choice of a candidate. So when you have a right to know under that, you are not asking the court to declare that in Article 19(1)(g), the citizen should have a general right to have a knowledge about everything and anything in relation to the affairs of the community. You have a task on hand, namely the choice of a candidate. So therefore, you need to know something about the candidate. Therefore, it follows that you must have information relevant for informing you as to how you'll exercise your choice. Therefore, the information issue will always be related to an expression with reference to a particular issue on hand. If you may put it like this, information relevant for determination of an issue, can be a freedom of expression. And that if there is a denial of that acquaintance, then we say there is an interference with the freedom of expression. So somebody calls it mutilation of the thinking process if the information is not available. So we talk about an issue on hand, and a denial of acquaintance of information forbids your ability to formulate an opinion and to reach a choice. So this scheme on hand is not concerned with political contributions per se. That's why I think the court would not get into the larger questions of where should political contributions come from? With what interest do they come from? And to what extent interests can be regulated? All those issues, I think, are completely alien to the scope of the inquiry in this case. That's why even if lots are invited to say the level playing field, it's only marginally relevant where one is looking at the effect of the scheme. Otherwise, those concerns, as I said, are completely alien to the narrow issue which is presented for consideration before your lordships. Because it happens in the generality of debates on election funding or political funding that one common starting point is that electoral reform is a claim that current systems somehow adulterates the outcomes that a purer system would produce. So we're not entering into the debate at all. Whether do we have a purer system and an adulterating system, how do you weigh them? Several imponderables would come into this question, both political, social, and economic. Therefore, that question not being relevant for consideration by the court. I'll read a very interesting statement made, not directly connected to this, but when the court is being asked to get into an arena of concerns, thoughts, and matters, and the court is asked to say, look, I step in and give something better. So that's these words by a famous economist, John Maynard Keynes, way back in 1933. I'll just give it to you after I finish reading this. Because when the community or even an individual is confronted with difficult choices, the question is in place of what prevails now, and if an alternative was to come in, it is not very clear about that alternative. I am perplexed. So he makes this very interesting statement. The decadent international, we are talking about capitalist power. Of course, capitalist power. But that capital today remains the lifeline of the nation. So he says this, the decadent international but individualistic capitalism in the hands of which we found ourselves after the First World War is not a success. It is not intelligent, it is not beautiful, it is not just, it is not virtuous, and it doesn't deliver the goods. In short, we dislike it, and we are beginning to despise it. But when you wonder what to put in its place, you are extremely perplexed. So these are very important words when any alternative system is sought to put in place. These questions have to be asked. So when we talk of the scheme being put to test and, let's say, undermining a basic structure doctrine, as Mr. Prashant Bhushan has put in his written submission, I want to deal with some of those issues so that straying away from the question for consideration and to sometimes draw a very broad statement about basic structure can become problematic. It can become too doctrinaire also. So I suppose the court it need not be called upon to enter into those questions at all here. There's one very inviting thought process that comes to all of us is that we tend to say basic structure doctrine is undermined or is in a way in peril. We tend to lose track of the features of the Constitution which are consolidated the basic structure. There could be an individual picture which can be undermined or in breach. So it is the architecture of the constitution which is brought in and say basic structure undermined. We have to give very close attention to whether that can ever happen at all in the way it is stated. I wanted to share these broad statements and a few more propositions before I take your lordships to. Just digressing here for a minute. We talked yesterday about free and fair elections and the level playing field, even though I said they're not relevant at all. I asked myself a question: if the information which now becomes coded under the scheme, coded in more than one way, is to be disclosed, and all citizens have a right to access to this information. What is that end which I will put to use by way of accessing this information? General political debate, or determining which party will do better, or we will talk about the quid pro quo after the quid pro quo event has occurred. So therefore, I'm asking the question as to for what end and for what concrete purpose is access to information, the information, if disclosed, would become relevant.
Come back after lunch. Well, feeling better?
Before the learned attorney starts,
Chief Justices in this country, but your sense of empathy, Malad, is phenomenal.
Yes.
before the learned attorney starts, there is a small request, my lord, if I can.
Yes, Mr. Mehta.
My lord, as I inform your lordships, my lord, on my request, senior officials of SBI are here, my lord. If your lordships would wish to be assisted in camera, my lords. If your lordships do not so wish, my lord, they can leave. That's the only purpose, my lord.
And, we would be averse to hearing them in camera because, then we don't put that to the other side. So
I understand. But my lord, as I said, my lord, if I start discussing in public, the purpose is lost. Therefore, my lord, I also was, my lord.
And we got the point. That has reference to that last line of the chairperson's letter to you.
Correct.
That we've seen, that there is a methodology of decoding the certificate.
Which is very complicated and detailed, and it leaves several digital footprints at several places.
We'll leave it at that as a submission, but we shouldn't be talking to them in the absence of the lawyers.
Please, sir.
But
They can
sealed
be,
covers would look at it.
Obliged, your lordship.
May I please, your lordship?
Yes.
To continue. So now I try to broadly make two important distinctions. One, what are the scheme sought to achieve and what the scheme has not addressed, or what it has not done and what it has done. So then we have some element of clarity on testing the constitutionality of this scheme. Before I go into that, so we have three, let's say, assume that a 19(1)(a) right is available to all citizens and must be made available to all citizens in order that we participate on an informed basis in a healthy democracy. Too broadly stated though it may be. And we assume that it is probably so necessary. Though I say today there is no such statement of law available except those two judgments where the statement of law is for the purpose of knowing the antecedents of the candidate, a specific concrete purpose to be achieved. So unless we say this larger purpose will be a specific concrete purpose, we may have to look at it very differently. But before I dilate on that, I proceed on the footing there is such a right available. And therefore, anything which may have a bearing on the citizens' expression of participation in democracy is a value, is an important value. And for that, it must know everything which must come to the aid of the citizen to participate. So therefore, disclosure, information is integral to that expression dimension. The other value which the scheme seeks to promote is confidentiality of the contributors, and which is an enabling part of the scheme itself. So the enabling part of the scheme is confidentiality of the contributors. It doesn't make a difference between corporate contributors or any other contributors. The scheme treats all contributors equally. It doesn't pick and choose between contributors. So that value of the contributor's confidentiality, and the more important value with the learned solicitor pointed out, that moving away from a cash, black money, unknown sources scheme to a relatively regulated scheme, and which serves the public interest of taking a first or a second or a third, whatever step one may call, towards ensuring a greater credibility in the funding process. We look at the question whether a nexus, a quid pro quo will have an influence which is hostile or adverse to fundamental values of democracy is a different issue altogether. Because that issue, in my understanding, which may go into a political party funding equality of opportunity, or whether there should be no political party funding at all. These are larger debates. You want to look at what you as Supreme Court has been grappling with this question. In Arizona case where the court says a matching contribution from public funds to publicly financed candidates. The court says that that places an undue burden on the freedom of expression. So all those things are in the larger political domain. Therefore, the equality of opportunity, free and fair elections linked to that equality of opportunity and level playing field, all those concerns, in my understanding, would require an analysis and evaluation which brings in norms and new norms for consideration and acceptance by the community and through parliamentary debates. Therefore, I don't think that aspect would probably be even invoked for the purpose of entering and looking at the three values which are in competition in this scheme. The public interest value, the confidentiality of the contributor's value, and the citizens need to know the information regarding who contributes to whom. Now, I ask myself a question. So how do you evaluate or balance these apparently competing, use the word apparently competing values? Yeah, I don't need to tell you lots about the three basic principles of proportionality, that there must be a legitimate purpose of a law, and it must have a racial connection to the object. And the next stage is that what the law does is must be to seek an object, must be least restrictive of all equally effective means. So the balancing test in this context would mean applying all this. And in a very involved situation like this, it would mean a cost-benefit analysis, which would bring greater cost in terms of effectiveness, bringing in effectiveness, credibility, purity, and which would not do that, and what kind of benefits will flow from that. That kind of a cost-benefit analysis, not necessarily in the economic or the financial terms, but in an empirical terms. So in the empirical terms, I don't think that kind of an empirical analysis has been made available to the court, and that has not been the scope of discussion before the court. I'll just give an example, because this kind of a cost-benefit analysis, which often comes in the proportionality domain, I'll give the reference to those cases. For instance, in Germany, we had in the province of Bavaria, crucifixion was permissible in public schools. So in a complaint given by those who did not believe that, the Constitutional Court of Germany said that there are two competing rights. The right of one set of people to say, I would not believe in this. The right of the majority of Bavarians who believed in display of crucifixion as a part of either a religious symbol or a cultural symbol. So there's balancing between two sets of freedoms. One a negative freedom, and another a positive freedom. This kind of balancing always comes in when we have very important social concerns in conflict. But some of those balancing can happen at a conceptual level. But very often, even at a conceptual level, it happens. Some right to the other yields to the other right. One right yields to the other right. So the yielding of it should take place under what criteria, what norms. That may differ from the right in question. When you're talking about this particular aspect of evaluation and the cost-benefit analysis of public funding or funding from any sources, public versus private, do we have all that kind of, an empirical analysis under norms which can guide the court? We say this is how we apply this norm. We apply this norm and find this is faulty on that norm. On the other hand, if the court were to call upon to create a norm and say that any funding from any source, more particularly from a corporate source, intrinsically is an evil dimension to it, then the court is called upon to create a norm. That's why I said in the footnote that we are not entering into the domain. But even indirectly, if that idea influences the analysis of the court, there could be this problem. I think that idea has been brought in to probably color the debate, saying that this issue is intrinsically an evil matter, that therefore keep that in mind. Therefore, disclosure will be very, very important. So the nexus between that aspect and the disclosure sought is somehow thought to be very subtly brought in. And I say, you'll also keep it in mind, that subtle connection we have to probably sever. Because we're only looking at the three competing values, diverse from all this, and see, therefore, is the court called upon to apply a proportionality test in this at all, if at all, then how would you go about doing that? I have my brief submissions. This is at volume 2. Volume 2. Like any reporting, the bar and bend reports, it says, the attorney says citizens do not have a right to know. So, I don't know where I said it in my submission. Let me read it out. Your Lordship, sir, could have volume 2.
Yes.
I'll quickly run through it, and then one of the aspects I wanted to probably also address, that in the context of 19(1)(a) and the Association of Democratic Reforms and PUCL.
Volume
And
2 of,
Your Lordship, please.
Volume 2 is the
Volume 2 is a separate volume.
Compilation of Union of India.
Convenience compilation also find it.
of the convenience compilation.
There's a convenience compilation.
Compilation of judgments and documents.
Volume 2 PDF 10.
Page
Volume
10.
2 PDF 10.
Lord Justice Khanna's got it? I'll be in the course of reading submissions, making
Mr. Attorney, we have read the submissions. Is there something that you want to highlight in particular in the submission?
Yeah, as I read a few parts of the submissions, I thought in my notes I kept what probably I would be talking about.
Great.
Lordship, kindly look at paragraph 5 of this submission, because the first 4 paragraphs like a kind of an introduction to, we don't have to go into the larger question of how the emanation of political parties and how, as a 19(1)(c) associations, it comprehends a variety of aspects of a political party, its supporters, its believers, ideology, and so on and so forth. Therefore, when a contribution to a political party comes in from either from a corporate or any other individual, it did not go under the color of a mere quid pro quo dimension. A person who supports a free market economy, and I find a free market economy which is propagated and supported by a political party, it will have my support. So beyond ideology, there are other considerations which bring about affinity between a contributor and the political party. So, and as I saw the tabular statement of all those contributors, it has all those small-scale industries, a wide range of small-scale industries. And we can't be fitted in to the quid pro quo dimension at all. That's why I said the scheme doesn't talk about a particular class of contributors. So these, I would probably be right in saying that the scheme is a regulatory within the broader concept of regulation, Article 19(2). As while an argument has been raised that the right to know 19(1)(a), cannot be subjected to any restrictions under 19.2 as they stand. An argument has been stated in the written submission, though not has been explained as how it really can happen. So I proceed on the footing that, in principle, the concept of regulation can flow from any one of those 19.2 to 19.6. If one is right in saying that derivative rights or penumbral rights, the way of looking at a right can be seen beyond the text of the right. If that is possible, I suppose, implicitly, and if it's also correct in saying there can be no right without a restriction, and I'm sure no court will say that I will postulate a right, but I will not visualize the restriction on the right. If that is so, the regulatory scheme under 19.2 to 19.6 can contemplate such regulations as would advance the purpose of the scheme. That's what I tried to stay in paragraph 5. So we are talking about moving from an unregulated system to a regulated system. So when you move from an unregulated system to a regulated system, the lawmakers may look into various aspects of how that regulation can minimally be and what kind of regulation will achieve the object. As has been explained in the foreknown, the various aspects of regulations fall into one composite basic principle. If that basic principle is confidentiality, which radiates in different directions, I find that the challenge to what has been stated under 29C of the Representation of People Act or the enabling part under Section 31 of the RBI Act, they all get connected by one common thread. Why have you amended this law, that law? The common thread is confidentiality. And the enabling part flows from Section 31 of the RBI Act. Once you enable, then how do you go about regulating? That thought process triggered which are those connected legislation which need to be addressed. Therefore, all those connected legislation which have a proximity to the question of moving from a unregulated to a regulated system, so they were addressed by the scheme and by the Finance Act, which looked at each one of the amendments. Therefore, I don't think one can say that I'll look at each one of the statutes in isolation and call them into question. So the approach that I'll look at the Representation of People Act, where the proviso says something, I look at it in isolation and says it's bad. I look at the Foreign Contribution Act and isolation, there is enabling foreign direct investment through a subsidiary company and so on, so is absurd, manifestly arbitrary. So this isolated understanding of each one of the legislation, I think in my understanding is flawed, fundamentally flawed. Because I said the common thread is one important common thread about confidentiality. May I just quickly read a few more paragraphs in this, my written submissions. Paragraph 6. The scheme does not impinge upon any existing right. I put it like that, constitutional or otherwise, of any person and cannot be said to be repugnant to any right under Part 3 of the Constitution.
Yes.
The Chief Justice raised a question yesterday. These are all statutory creations. A right came, a norm came, a disclosure came, it went away. What came by statute has gone away by statute. So if there is a restraint upon disclosure, it has been taken away by a statute. In that context, if all these, even a disclosure under the Section 182 of the Companies Act came by way of an amendment of the Companies Act. Unless one is persuaded to say and one is also able to accept that proposition, that by reason of the statutory amendments, you acquired a right to have it retained as part of a constitutional scheme. And therefore, any change in this legislation for any purpose whatsoever, including a public interest purpose, an important regulatory purpose, regardless of all that, that will be put to test. I don't know whether it can be stretched to that extent. So the debate from 1958 onwards and the Companies Act, 69 one way, and then in 85 another way of looking at it, the debates in the parliament we wrote yesterday, show a very multi kind of discussion which took place in the parliament. So I'm not sure whether anybody can come with the proposition that as a product of these statutory changes, certain inalienable, indestructible, inviolable rights occurred, and citizens have a right to ensure that they are not tinkered with. That amount to enhancing all these statutory changes, amendments, statutory creation to the level of a constitutional principle. If you may just read a couple of more paragraphs. Paragraph 7. Lord kindly, the petitioners seek a declaration, though not the declaration is expressly sought in the petition. But I proceed on the putting, they want the declaration. The citizens have a right to know as an aspect or facet of the right to freedom of expression. Based on such a declaration, it is canvassed that the right to have access to the details of contributions to political parties must follow. Consequently, the confidentiality facilitated under the scheme is said to be impermissible. The above submissions are refuted on the following basis. Firstly, there can be no general right to know anything and everything without being subjected to reasonable restrictions. Secondly, the right to know as necessary for expression can be for specific ends or purposes and not otherwise. Arguments were raised yesterday about shell companies, and information was also showed to Lordships yesterday that the government has taken, I think, is continuously on the watch and vigil about shell companies. 2 documents have been placed for the Lordship kind consideration. I don't think I need to take a Lordships into those, each one of those statutes and analyze them for the purpose of understanding what they propose to do and what they fail to do and all that. But in view of my larger submission that they're all connected by one common thread, namely confidentiality. Then finally come to paragraph 11. Again, it's a facet of my submission in paragraph 7. The judgments in so-and-so, where in the context of making informed choices about electoral candidates and knowing their antecedents, information limited to such knowledge serves the specific end of citizen choice of electing candidates free from blemish. Right to know for specific rightful expression was thus conceived. From that, it cannot be said the right to know for general or broad ends necessarily follows. Therefore, these judgments cannot be read to suggest that a citizen has a right to know that under Article 19(1)(a) regarding funding of has a right to information Article 19(1)(a) regarding funding of a political party. If there is no such right under Article 19(1)(a),
you have carefully gone through all your submissions.
Lordship, please, sir.
You have carefully gone through your written submissions. So if you want to just
No, as I read a couple of them, I want to make some explanations about it. So the further question of restrictions does not arise in 19.2. Kindly turn to the next paragraph. Because why we talk about reading the PUCL and the Association of Democratic Reforms judgment in the way they ought to be read. The court proceeded on borrowing what Justice Douglas talked about, the penumbral rights under Griswold v. Connecticut. I suppose that the issue of penumbral rights and reading into 19.1a in the context of general right to know about political funding may be misconceived. I just want to read a couple of paragraphs from Maneka Gandhi and this concept of peripheral rights and how we have looked at it. That judgment you'll also find in volume 2, 2b.
Page.
Just open it right from here.
Graphs, we'll read them later, Mr. Attorney.
Yeah,
You can
that's
just
in
state the
volume
point.
2, 2b.
2B. What paras would that be?
Paragraphs 32 to 34.
We'll have a look at it because that discussion on penumbral rights, we'll look
Yeah,
at it.
that's right. This first sentence in paragraph 33, which is the page 65 of this volume. Just that one sentence. We cannot therefore accept the theory that a peripheral or concomitant right which facilitates the exercise of a named fundamental right or gives it meaning and substance or makes its exercise effective is itself a guaranteed right included with the named fundamental right. That's why I was.
But this logic
trying
has
to
also
point
now
out.
undergone a change after Puttaswamy. And Puttaswamy is 9 judges.
But
So there is no right to privacy. There is no right to privacy expressly recognized by the Constitution.
But
But we read in that right in the right to life, liberty, dignity, the preambular values. So
those probably will stand on a broader conspectus. Therefore, the court will draw a classification among those rights where this kind of a broader reading to effectuate a constitutional purpose. They may stand on a different footing. Therefore, I do not know whether this statement of law is in direct conflict with Puttaswamy. It may not be. Yeah.
Mr. Attorney, we'll have a look at the.
Yeah. May I just go
What else,
to,
Mr. Attorney, now in your submission? Any particular submission that we have missed?
yeah, in paragraph 15.
That you have made a point that the scheme extends the benefit of confidentiality to the contributor.
Yeah,
The
the
learned
second
solicitor
part
has
of
also
that,
elaborated
second
upon
part of
it.
the sentence. Therefore, I say this scheme does not fall foul of any existing right. So a constitutional court reviews state action only if it impinges upon existing rights and not because state action has not provided for a possible right or an expectation, howsoever desirable. So even if you go to the extent of saying 19(1)(a) in the context of knowing this is desirable, you probably will not fault it on that ground. And that's what I repeated in paragraph 16. Yeah, just open this.
Your last point really in para 18 is that when the court proceeds to declare an aspect as part of a right, it will be in tune with separation of powers that the subject of reviewing or testing a law should be relegated to public and parliamentary debates. Declaring an aspect as a part of a declared right does not impinge on the separation of powers. For instance, we have said that sexual orientation is implicit in Article 15. That does not impinge on separation of powers. If the court were to lay down a legislative remedy, that impinges on the
That's why
separation
we're talking
of
about
powers.
laying down a norm.
But finding a right in a constitution, finding a right in the constitution
No,
does
I
not.
don't.
For instance, we have said the right to education, even before it became a part of Part 3, we said the right to education is a part of
I didn't say that.
21.
But when you lay down a norm which probably would require an analytical framework and weighing in fine scale the variety of concerns and interests.
No,
The
we
laying
have
down a
an
norm
analytical framework.
beyond reading into a right.
No, we have a framework today. We are not creating a framework. We are testing the validity of the framework.
The framework available today is in the context of the scheme, this particular scheme. There is no framework with reference to which one can say the scheme is unconstitutional. The only fulcrum is 19(1)(a) that I have a right to know.
Thank you,
That's
Mr.
how it
Attorney.
is.
I think, Mr. Attorney, we've understood the submission. Should we close here? So that we'll give a little time to Mr. Amit Sharma.
I'll just take a few more minutes and
for them and rejoin them.
I know, I understand. Rejoin that time is important. Just a few more propositions of how you test a law. Generally, these are well-known statements of law. Attempt was made to show that judgments which intended consequences. Consequences intended in 1955 expressed newspaper. That is. Let me quickly read these 2 or 3 statements about statements of law and how do you construe.
We've gone through your written submissions. If anything else to be added to those written submissions, I thought whatever you wanted to express yourself, you have expressed yourself.
I'll do that. Just by way of conclusion, much was said that the ruling party gets a disadvantage. That's not a consequence of the scheme of independence. Even if there's an unintended consequence, it is not an intended consequence. An unintended consequence, court will not strike down a law on the basis of something which happens.
That the learned solicitor has already argued, merely
So
because the
unintended consequence is not
because
the
the
reason
provision
for
is
striking down the law.
capable of being
I just want to give those two or
Excuse.
three judgments on that right from Express newspapers,
In fact,
1954 onwards.
uh,
So what the
Solicitor
law does,
General has made it very clear that this has been true right from the beginning. So the effect thereof, we'll examine that.
that's good.
Thank you, Mr. Attorney. Thank you. Mr. Amit Sharma,
Those
would like
4 or 5 judgments, I'll put them along with a
just
note.
give us a
instead
separate
of,
note you can do that.
Yes.
Yes, Mr. Sharma. Mr. Sharma, how much have you collected by way of, you're not the State Bank of India, but in terms of the records which you have, what is the extent of the total quantum of electoral bonds which have been subscribed since the beginning?
That's in a sealed cover, my lord. So we have not opened that cover at all. Because that was directed, this honorable court had directed that to be in the sealed cover. And my lords, if my lord desires that sealed cover is there, my lords can have peruse it, my lords. But we've not opened it, my lords. We can.
Mr. Sharma,
Yes.
actually, the details of the bonds are available with you. Total quantum of bonds is available with you. Quantum of bonds given to the,
Yes, my lords.
that is there. So do we get any particular data? And is the data up to date? That is still, at least till March 23?
No, my lords, that's not there, my lords, with us. We have only till, in fact, there was a query by this honorable court, my lords. I went through the record, my lord. There was one order passed by this honorable court, which my lords had read 13 and 14 paragraph of 2019 judgment, my lords, separately. We took it as if it's to be read jointly, my lords.
No, it was very.
But my lords, I may just point out.
13 relates to data as of the date of the order. But it didn't freeze the data which you had to maintain as of the date of the order. You had to continue to collect the data.
Just, my lords, if my lords will kindly see.
Mr. Sharma, you should have asked for
Order passed in
clarification.
2021.
You never came back to us to ask us whether we want
May I just point
continuing
out-
data or frozen data as of the date of the
The
interim.
occasion could not arise, my lords, because of the order passed by this honorable court subsequently on 26th of March 2021, and my lords will find that in the, my lords, at page. Kindly, my lords, it's a EB final, my lords, which was filed by the petitioners, my lords. And that's at page 34, my lords. That was passed in one of the interlocutory applications filed by the petitioner, my lords.
Volume 3.
Page 505.
Volume 3.
which page?
6th March. Volume 3.
I will just tell. My lords, they have, I don't think that has been filed in the volumes, my lords, that's missing. But one of the initial volumes filed, my lords, that's called EB final, which I received through email, my lords, that was filed on 5/4/2023, my lords, by the petitioner. That's at page 34 of this, my lords. And my lords will kindly see this order and the relevant paragraph in this order, which my lords, I would like my lords to read is. That's right. That's right.
Volume 3, page 505. The court paper, volume 3, page 505, that order is.
Oh, thank you. And my lords will see, kindly see para 19, my lords. Of
Which
that,
order?
my lords, order dated 26th of March 2021, which was filed, my lords, which was passed in interlocutory application number 183625 of 2019 in the present writ petition.
26th of March 2001.
21, my lords, 2021.
Is there? at the volume which you had mentioned also. 50.
Volume 3505.
Yes.
And para 19 is at page 519, which he wants your lordships to read.
Milords, it took note of the entire earlier directions, Milords. This order takes note of the directions passed by this Honorable Court, pursuant to which the compliance done by the Election Commission of India, Milords, and then further, Milords, para 19. This was a second application which was preferred by the petitioner, Milords. The first one was rejected, and thereafter the second application on the same ground, Milords. That's also discussed.
Where is the discussion with regard to paragraphs 13 and 14?
Lords, my lords will kindly see. Paragraph 12.
This was a application for stay, if I'm not
stay.
mistaken.
That's right.
Because a fresh window was opening up
That's right.
and Mr. Prashant Bhushan sought a stay at that
That's right.
stage.
That's right.
On collection of any further amounts
That's right.
and,
That's right.
you know, and the distribution of any further electoral bond.
That's right. Absolutely. And para 19 laws, it says that as far as the information to the Election Commission is concerned, the interim order passed by this court on 12/4/2019 takes care of the same. In the reply filed by Election Commission on 3/2/2020 to IA number so and so of 2019, it is stated by them that Election Commission of India has received seal covers from various political parties, national, state, and registered and unregistered parties in annexure C1 to the reply filed by Election Commission of India, provided the list of political parties who have filed necessary details as per the order dated 12/4/2019, the date on which Election Commission of India received. Milords, so Milords, perhaps Milords, this may be a reason, Milords, that, but we are Milords, we bow down, Milords. If there is any direction, we'll provide it, Milords. There's no difficulty on that. And Milords, the
You should
order.
have got the data. You should have got the data
Milords,
when you
in
are
fact,
coming to the court.
If I may say, Milords, if my lords will kindly also see para 13 and 14 once again, Milords.
Oh, please, Mr. Sharma, this is not what was, we read out that order that day, prima facie. All of us had expressed the view and we expected you to come back with that data.
We can provide it during the, maybe in a short time, Milords. I'll instruct the commission, Milords, that.
And is the
By
data
Monday.
right up till 2023, March 23 now available?
Milords, we'll seek the data from all the political parties, because Milords, it has to have a detail, Milords.
What's the time limit when the data is to be given every year?
Milords,
Every financial year it's to be given? What's the time limit for, what's the deadline
the
for that?
data is not to be given, Milords.
So, with regard to the
That
returns
is the
file,
annual, yes, Milords.
when is that to be given?
Milords, before the financial year, Milords, ends.
That means 2024,
That's right.
31st March 2024,
6 months before that.
6 months.
6
before.
months after the financial year, Milords.
So 6 months are over, September they got over. So you must have got the data.
It was not the data, Milords. That's what I'm trying to say.
Whatever the,
Only the quantum.
Up to 31st of March 22, you have any, 31st of March 23, you have the data.
Yeah, we have, Milords, but
You would have the data or ought to have the data.
It's only the total quantum, Milords, not the.
Right, you will have the total quantum,
Yes,
quantum of electoral bonds.
That will have, Milords.
And what is the bifurcation between different political parties?
Milords, that,
yes,
Has to
sir.
be,
Has
because
to
it's
be.
like-
we'll have to collate all with all the, yes, we'll
Because
have that.
parties have to give you submit contribution
All
reports.
the recognized political parties, Milords, and registered, whether registered or not, Milords, we have.
So we'll have a look at your data. You can
Yes,
trace the
Milords.
data. Now tell us one thing. What was the basis on which the Election Commission had raised an objection to the scheme?
Milords,
Can you tell us what the nature of your objection
yes,
was?
kindly see, Milords, there are 2 letters that we had written, Milords, to the Ministry of Law, Milords. Kindly see these letters. There are 2 letters which are dated 15th of March.
But I didn't deal with that submission, my lord. But I have the original file with me.
Yes.
RBI and EC, but after the correspondence, after their letters, there were meetings and meetings, and thereafter, my lord, a consensus decision was taken. There were meetings after the latest, my lord. If your lordship would like to peruse, I can show that file, my lord. Original file is here. But that's not an end of the matter. We thereafter discussed
that happened.
their concerns were taken care of. Their misgivings were, my lord, it was at the highest level, my lord. Meetings were attended by the governor and minister, etc.
Because that's come out in the rejoinder of the union also, yes. That there were meetings which happened after the deliberation was.
So what was your objection and to what extent was it assuaged?
One of the concern that we had, my lords, is that there are three categories basically, my lords are aware. One is below 2000, the other is between 2 to 20, and the third is, my lords, I am not talking about the electoral bond for a moment, my lords. I'm talking about the general contributions which happen, my lords. So there are broadly three categories: below 2K, between 2 to 20, and above 20, my lords. Now, as far as, my lords, above 20 is concerned, it is to be done mandatorily by way of ECS, my lords, either demand draft check or ECS, my lords. So that's not an issue. We get the entire details. My lords, as far as these other previous two categories are concerned, my lords, less than 2000, my lords, it can be done in cash and there are no details about it. We are mostly concerned with the second category, my lords, that is between 2000 to 20,000. Now that there is no provision given either. It can be done by cash, it can be done by ECS, it can be done by check or draft notes.
No, but it was said that after amendment to 2017
Please.
under the Income Tax Act,
Please, my lords.
if it is between 2 and 20, then it will be treated as income, which is not allowable, which will be then taxable in the hands.
Please, my lords. So income tax has that, but vis-a-vis income tax, the RP Act, my lords, 29C, that amendment or that change,
You have not, under your rules, you have not made
No.
made a stipulation.
it has not happened.
It has not been stipulated that between 2 and 20, you please specify. And is there any also a rule with regard to multiple payments by the same person?
No, my lords. There is no rule as such.
There's no rule as
There is
such.
no rule. Any person says.
But do you have data with regard to 2 and above 2 and between 20?
My lords, we don't have a data. That's the difficulty because
You have data below 20.
above
Quantum,
20, of course, my lords, we have it.
above 20, you have the particulars. Below 20, it's just the lump sum amount.
That's, my lords, we receive a contribution report, my lords, every year. Now, in that contribution report, we get the quantum as to how much in total a particular political party has received the amount above 20. Now, what?
And have you made any study or analysis of the data dealing with the corporate bonds and how it's impacted the funding of political parties?
I'm not aware, my lords. I don't think, my lords, but I'll have to seek instructions. I don't think. I'll have to seek instructions on that. I don't know whether there has been some ongoing study on that or not, my lords.
Now, volume 4, page 467 was your letter of 26th of May 2017.
Please, my lords.
In what manner were these concerns assuaged?
Lords, kindly, if my lords will see this 26th of May, my lords. The first is, my lords, about that section that I just spoke about, my lords, section 29C, that we wanted that same principle, same provision which is there in IT Act to be brought into 29C so that we also get to know, my lords. So that was one concern, my lords, which we had highlighted. And which is now, my lords, contribution above 2K is now included, should be included, my lords, in 29C. So that, my lords, there will be a proper quantification as to how much is in that bracket, how much is coming with a particular political party as a donation, which we don't which we don't have as of now. There is no breakup of that. We only get the total amount, that this is the amount which we have got in that particular category. So we have no data on that, my lords. And we don't know the source also. So See your volume. Whichever point.
Of
12th April 19, right?
12th April 19.
Volume 1, page 15. Volume 1, page 15. Oh, I don't know. Twelfth of April 19 order.
Yes.
Volume 3.
Volume 3.
As per you, you don't have data after 2019.
No, my lords, unfortunately, we don't
You
have
have
it. But
collected the
I
data
put
with
down, if my
PF.
lord directs, then I'll instruct the Lords Commission and
Our direction is already there.
but we can get the latest, my lords. Till the last window.
Till
23.
23.
Actually, the order which we While the data as of
The latest, till
The
till the
latest.
last, yes.
as of 31st of March 2023 and submit it to us.
We'll do that, Milods. We'll do that.
And in fact, why, you can even give it to us, say up to the 30th of September if there's data.
Till the latest, Milods, whatever we have, till the last that we
You
have.
won't be having, you'll have
We'll
to
have to
either.
require, Milods, till the
one-
last that the
Either
political.
you
parties
get
have
it
done.
from the political
Please,
parties
Milods.
or you'll get it from the
State Bank of India.
State Bank of India.
Either of.
We'll not ask SBI to reveal the identities of the donors at this stage. That nobody is interested in at the present stage. But we would like the order we said, the just and proper interim direction would be to require all political parties who have received donations through electoral bonds to submit to the Election Commission of India in a seal cover detailed particulars of the donors as against each bond. The donors is also come in there.
Exactly.
The amount of each such bond and the full particulars of the credit received against each such bond. So you give us the data that you have up to 30th of September.
That can be, Milods, because the details of the donor, that's why in seal cover, Milods. Otherwise, Milods, data can be, the quantum can be given.
Just show us what you have got up to now, up to 19. Keep it in the custody of the court. They have given separate seal covers for each political party
We
separately.
have to file there. So, someone may have to collect it, to assist your lordship from the registry or whichever, my lord, authority.
So we are really dealing with a constitutional point. I mean,
Actually.
this has no bearing on how we decide the constitutional issue.
No, this was really meant for, suppose a writ petition is allowed, it should not be then confronted with the situation.
Yeah.
That nothing, no details can be made available.
No, I was on a different point, my lord. This might possibly have everything received by everyone,
No, it's separated.
separate.
It's separate by each political party.
Then there is no collation also.
Collation is already done.
The order is to the political party.
No. The order is to both, everyone.
Both,
I don't
yeah.
think political parties or party,
That's right, all of them. They have to, that's why they're
they
separate.
had to get it from the political, because they are the ones who are.
Yes, yes, of course, of course.
So should we hear Mr. Sibal now, I think? Yeah. That you want to add?
That's the only concern that we had, my lords. And this IT Act concern, we had raised it before the electoral bond in 2016 itself, which we have mentioned it in our counter affidavit, my lords. So that was the
Thank you.
DP of electoral.
Yes,
Your Lordships, but I didn't address your Lordships on how we addressed their concerns, etc. Would your Lordship like to
Okay, tell them.
assist it? Because it was more a consultative process with them. After having received.
A note of the fact that you had that you were consulted.
RBI and EC can't be taken lightly. Madam.
You have any, does the EC also have any idea what was total expenditure incurred in the last election? No.
That we'll have. Total expenditure, yes, my lords, because there are three heads that we receive the accounts. One, as I said,
So, but as far as political party expenditure is concerned, do you get data with regard to that also separately?
my lords, we get data of every candidate who has to file.
Candidate will not be suffice because
My
the
lords, as
political
far as
party.
political parties are concerned, my lords, we don't get the expenditure of a political party in a particular election, how much they have spent. It is candidate
So
specific,
then your data is incomplete.
candidate specific, my lords, because that's
It's not, you don't get the data with regard to
how
all
much
the
in
political.
total
parties.
the political party spends, my lords, that may be,
No, that will be with the income tax department will be there.
Possibly, maybe. I'm not.
No, I'm asking him because he's the one who.
no, that's right.
So, Mr. Prashant Bhushan, 15 minutes in rejoinder for you.
20 minutes. You're not
Thomas?
going to give me just 20 minutes. I'll finish by 3:30.
But we'll have, now we have 50 minutes. So you, Mr. Sibal, Mr. Hansaria and
Press it
and
for
Mr.
15,
Parasa. 5 minutes. all right.
15 minutes extra if necessary. That's
We'll wrap up today.
Only to
Yes.
answer your Lordship's query, the political party's expenditure is a part of their annual accounts, which is filed with election.
Election committee.
I stand corrected, my lords. We have the, my lords, I stand corrected. We have the data of the political parties, my lords. We have the data. I stand corrected.
Yes, Mr. Bhushan, what do you have to
yes.
say?
So the first argument of the solicitor was that because of these amendments, the volume of cash which is coming to political parties, which he says are maybe black money or is likely to be black money, that has gone down.
No, that's not his argument. He doesn't make a quantitative statement. His contention is that this was an effort which was made
Yeah.
to bring into the accountable channels
Yeah.
what was otherwise completely beyond the fold of accountability because the earlier schemes had not worked.
So let me just deal with that. Firstly, my lord, it did not close the cash channel. The amendment has left open the cash channels. The only change that has been made is that for getting income tax exemption, that 20,000 has been brought down to 2,000. That's all. Otherwise, donations up to cash donations up to 20,000 can be given to political parties and they are not required to be reported. Quite apart from the fact that actually 20,000 or 2,000 does not make any practical difference because all that the political party declares is, I have received X crores as cash donations, which are below 20,000. They used to say below 20,000 earlier. Now, if they want to avail of income tax exemption, they say it's below 2,000. So they say that we have received whatever, 100 crores, 500 crores by way of petty cash donations. Earlier, petty meant below 20,000. Now, petty means below 2,000 if you want to avail income tax exemption. Practically, it makes no difference in my respectful submission to the availability of cash to political parties or the ability of individuals to give cash to political parties. Practically, that 2,000, 20,000 makes no difference. Now,
That will not impinge upon the validity of the scheme.
yes, I know. Lord, they are saying that this whole exercise was to bring down the element of cash in the economy. They say cash is equivalent to black money. The object of the exercise was to make political funding of parties to come more through banking channels rather than cash. This, they say, was the stated purpose of this whole bringing in electoral bonds,
Mr.
one of the
Bhushan-
stated purposes.
Mr. Bhushan, there will be slight difficulty. Even if it has not happened, probably the data may support you, the cash channel may not have come down. It
No,
may-
cash did come down. I'm not saying cash didn't come down, but the reason why, it's important to
But
understand why cash
Mr.
came
Bhushan,
down.
there are three, four arguments on which we want direct answers.
Yeah.
One is that the intention was to ensure that the money comes through regular banking channel.
Yes.
There is a KYC required,
Yes, yes.
which is not there as far as payment
Cash,
is concerned. And also, even if it is coming through the bank accounts,
yes.
the KYC by the second KYC at the time when the bond is purchased is a second added advantage.
All right. Let's assume that that's there.
Number three, their contention is that as far as payment is concerned, the person who's made the payment is concerned, the need to know the name of the donor has been protected. The confidentiality of the donor has been protected
Yes,
for 1, 2, 3, 4 reasons.
yes.
And therefore, when you are examining the reasons, you will have to take into account what was the intent behind the enactment,
Yeah.
and not by a counter argument, which may be. And there has always been a conflict between confidentiality and declaration, or
So, my lord, in
both of them have their pluses and
Yes.
minuses.
to answer our argument that these changes defeat the citizens' right to know about who's funding the political parties because they introduce another anonymous source of funding. Now, the answer given by the solicitor to that is that, well, it had an objective. Now, these are two conflicting things. They say the objective was to limit black money or cash money coming to political parties or to reduce that. And therefore, we introduced these electoral bonds because many individuals or companies do not want to be known that they are the donors to these political parties because they fear victimization. So that was what the finance minister then stated. That's the argument also of the solicitor, that there was an objective behind this. Now, what I'm pointing out is that if the objective was to choke off cash donations have not been choked off.
But that was not the object at all.
Yeah.
The object, as the finance minister says in that article, and that's broadly an indication,
Yes.
was to add some element of transparency. That's what Mr. Jaitley said, that it will enhance transparency to a significant extent, and we would add two separate phrases which have been used. That's the point. You're right. In the earlier regime, absent this, it was purely cash based. You had those options, voluntary contributions, you had electoral trusts. But
Not just that, you had direct check donations, etc. That is,
a cash based scheme, an unaccounted scheme, proceeds on anonymity.
yes,
According to you, they have continued anonymity.
yes. They have
But,
continued that anonymity
but,
of
there is,
cash.
but there is
well
one
as-
change. But there is one change.
Yes.
That the electoral bonds have brought whatever is contributed to the electoral bond in the form of accounted transactions within the normal banking fund.
Now the question, so that's the second limb of the argument, that this reduces black money flowing into political parties because it's coming through banks. Ultimately,
Whether it reduces or not, to my mind, is irrelevant to the validity of the scheme.
all right.
The scheme may be wholly unsuccessful, but it may still be a constitutionally valid scheme.
No, Lord, then that is no response to my original submission, which is that it defeats a constitutional right of citizens to know who is funding these political parties. That's a fundamental right which your lordship has recognized under 19(1)(a). And if what is being argued, that the object of this bringing in electoral bonds was to reduce cash and reduce black money, so to say, and bring in only accounted money through banking channels to political parties. If that's the argument, then I'm just pointing out that that's not entirely correct for the reason. Firstly, you can still give cash. There is no bar today which has been placed on cash. The only change that has been made is simultaneously.
How do you put a bar on cash?
But-
It's a third economy. Much as you may impose a bar on cash, it's illegal. It's illegal, but you have a third economy.
That's the point, my lord, that it could easily have been done that all receipts of political parties, at least of political parties, will have to be accounted, whether it is cash or not. All cash also, any money being received, you could have done either of two things. One is to say cash is totally prohibited, you have to take through banking channels. This is one option. The other is, even if you take cash, irrespective of the amount, even if it is 100 rupees, 50 rupees, even the RBI, when it dealt with this electoral bonds, when it responded to electoral bonds, they said that if your object is to make political funding go through banking channels, there are existing instruments of checks, drafts, bank transfers, etc., which are available. Why are you introducing this anonymous instrument? This will allow, because as I pointed out, Lord, it's not that black money cannot come in through electoral bonds, though it will come in through banking channels. The example that I had given in my initial submissions was, suppose, as has been done, that you, by under-invoicing, over-invoicing, etc., you siphon out some funds, X crores or X thousand crores, to tax havens. From there, my lord, you have a company to which you have deposited. That's all black money. It's over-invoicing, under-invoicing money which has been siphoned out to those tax havens. You set up a subsidiary of that foreign tax haven company in India. It's a subsidiary under the FCRA changes. It was argued, my lord, FCRA is not in question here. But FCRA changes have been challenged in this very petition also, 2016, by which the availability of even subsidiaries of foreign companies to donate to political parties was brought in. And whether or not your lordship decides on the validity of that or not, your lordship have to keep in mind the fact that simultaneously that route was opened up. The route of subsidiaries of foreign companies donating to political parties was opened up. Now, what I am pointing out is black money can still flow through electoral bonds in this way. You have converted black money and deposited it into a tax haven bank account of some company registered in a tax haven. You then transfer that money you set up a subsidiary in India, transfer that money to a subsidiary in India. That subsidiary company, because you have removed the limit of 7.5% also, even if it's a shell company.
Mr. Bhushan, at a constitutional level, this argument won't wash. I'll tell you why.
I am only responding to what was argued, my lord. I am not.
This will not wash.
Formation of subsidiary company.
This will not wash at a constitutional level for the simple reason that the fact that they have been unable to, or they did not, dry all cash sources of funding of political parties is not an answer, there is not a ground to challenge the validity of a scheme.
I'm not using that ground. I am saying that the response of the government to my ground. What were my grounds, my lord? My ground was Article 1918 defeats the rights of the citizens to know the funding of political parties. Number two, my lord, it promotes corruption because it effectively legalizes corruption because it allows any company to give anonymous kickbacks, legalized anonymous kickbacks to the parties in power. And I pointed out that the evidence, there is considerable evidence to show that almost all the electoral bonds have gone to ruling parties. Vast bulk to the ruling party in the center, the rest to the ruling parties in the states. And virtually all the electoral bonds that have been purchased are in 94.5% in denomination of 1 crore and the remaining in denomination of 10 lakhs, virtually nothing below that. Therefore, there is good reason to suspect. And I gave two examples also. I'm not saying that your lordship should use those examples because those parties, those companies are not before us. But I gave those two examples. One company has declared officially that they gave those electoral bonds to ward off excise issues which had arisen with the government. The other company who has purchased electoral bonds worth more than 450 crores from their accounts declared to SEBI has been the recipient of several mining contracts and various other favors.
You already argued, Mr. Bhushan. You're in rejoinder.
These are all auctions. Mining contract
You're in the rejoinder now.
Kickbacks. You participate in auctions.
Don't re-argue your case.
I'm not re-arguing. I'm just pointing out that that's my argument. Now, what is the government's response to that? So how do they answer this question that this defeats the citizens' right to information? One answer that they have given, I was coming step by step. One answer that they had given was that there was a competing interest of bringing down cash or bringing down unaccounted money into the donations and finances of political parties. I am just answering that issue. The other argument that they have made is that there is a right to privacy. That's the argument made at the end. Firstly, my lord, the right to privacy doesn't extend to companies. It's an individual human right. Even in Puttaswamy, your lordship have laid down that that's an individual's human right. It's not a right of a company. So therefore, so far as those amendments which have been made to the Income Tax Act, to the Companies Act, etc., which anonymize donations by companies to political parties and remove the requirement of declaring who you have donated to or where you have spent this money, that right cannot be invoked for companies. The right of privacy cannot be invoked for companies. And even otherwise, my lord, if let's assume that there are some individuals who are giving this money, the question is, can those individuals claim a right to privacy which overrides the right to information of citizens? Even under the RTI Act, if your lordship recalls, there is an exemption for privacy. There is an exemption for personal information. But that exemption stated that only that personal information which has no bearing on public affairs and which cannot be overridden by public interest is exempted. If there is a public interest override, even that information is not exempted. So in my respectful submission, my lord, that privacy argument cannot be used to say that my right to privacy about which political party I am donating to overrides the citizen's right to information to know about who the political party is getting funded from. So that right, my lord, in a clearly would override, even if there is a right of privacy of an individual. Of course, companies don't have that right, but even if an individual has that right of privacy about donating what they have donated to political parties, in my respectful submission, that is overridden by the citizen's right to information. The other argument that was made was, again, on the basis of what the finance minister had said. It was argued that this is to prevent victimization. Now, Firstly, as your lordship pointed out, the government would certainly know, or the party which runs the government can find out, ki, look, this company had purchased electoral bonds worth 100 crores. We have not received anything from it. Therefore, obviously, they have given it to the opposition parties. And therefore, that much information which will still allow the government to victimize that company is always available with the government. Even if they do not use their control over the state bank to find out which company has given electoral bonds to which party. The argument that was made was that no, there is an elaborate system of protecting that information. It's very simple, my lord. Obviously, when a person purchases an electoral bond, he gives KYC, etc., the bank would have to record that this person or this company has purchased this electoral bond, and the number of the electoral bond would have to be recorded somewhere. Thereafter, my lord, when a party encashes that electoral bond, the number of the electoral bond which that party has encashed would have to be recorded. Otherwise, my lord, it would make it open for counterfeiting. And therefore, you have to record these two informations. So therefore, it's not so difficult. If the government wants, State Bank of India would certainly know. And if the government exerts sufficient pressure on the State Bank, they can come to know. Even otherwise, my lord, the government would know as to which companies have purchased electoral bonds worth how much, and that we have not got it.
So one point is, of course, you have highlighted the citizens' right to know. What is the next?
Right to know that the sphere of the justification for victimization, etc., doesn't really apply. In fact, it's only the citizens who are being deprived of this information. Each political party would know, can know, and certainly the government can know. A citizen cannot, my lord, scan the.
Mr. Bhushan, I think point in the joint up.
And then, my lord, just two more things. There was an interim order, as your lordship saw,
Yes,
asking the
12th of
Election
April,
Commission. I am respectfully saying, because they are going to open electoral bonds window for this state assembly elections any day now. It can be open tomorrow, it can be open day after. And again, my lord, till today, till March 2022, electoral bonds that had been purchased were over 9,000, under 10,000 crores. Till today, I understand that the electoral bonds that have been purchased in this last 1.5 years has taken the total to 13,000 crores. Now, today, if they open the electoral bonds, again, in this assembly election, again electoral bonds will go. I am respectfully, my lord, requesting your lordship, even if your lordship does not stay the issue of electoral bonds after today, at least one thing your lordship should say, that it should be made clear to the parties who are purchasing electoral bonds that these may be subject to disclosure. Because this court has the power under the scheme also to seek information from the State Bank of India. And I am requesting, my lord, that at the end of this, if your lordships agree with us that this electoral bond is unconstitutional, etc., then your lordship should disclose as to which company has given to which party, etc. And even if that information has to be obtained from the State Bank of India. And that's why, my lord, I am saying that at least today, because last time the same thing happened in that Election Commission appointment case. I had an interim application. I mentioned that interim application on Thursday, on saying that there is one post vacant of the Election Commission, and the court is proposing.
Except for the difference, except for the fact that after the 12th of April 19 order,
Yes.
when you moved a fresh IA for stay,
That was for that particular.
That stay was declined by the then.
Yes, yes,
chief judge.
yes, that was at
Mr.
that,
Bhushan,
at that stage
Mr.
for
Bhushan,
that particular.
That's why I asked,
bond.
what is exactly your prayer? You asking for quashing of the?
Of course,
entire-
I'm asking for caution.
Just 1 minute. You asking for quashing of the scheme, or you want that the disclosure should be made?
No,
of the
I'm
donation?
asking for quashing of the scheme.
Okay,
of
therefore,
this
you had
anonymous
to
scheme.
answer that question.
And in case your lordships.
Mr. Bhushan, just one more question.
Yes.
The scheme has one advantage. There's a KYC at least. You will accept that there's an advantage in that.
No, that's all right. If the anonymity is removed, I have no problem.
So therefore, you argue on that.
I'm saying I'm challenging the scheme because of the anonymity. Remove the anonymity, I have no problem with electoral bonds. I'm challenging the anonymity of the electoral bond. So that is defeating the right to information of the citizens. So, so what I'm saying is,
So you are basically pressing for the entire scheme to be set aside, and you're also arguing that the amendment should therefore be
The law that applies to a candidate doesn't apply to a political party. Why? What's the rationale for that? What's the basis, Malad, of coming to this conclusion? These electoral bonds are meant for a political party to be in power in perpetuity because the amount of money through these means, which quote unquote are legitimate, will empower that party through capital to influence everything. This is the most unconstitutional, undemocratic, unfair scheme that destroys the very basic structure of our constitution. Free and fair elections is the basic structure of our constitution. This scheme is neither free nor is it fair. It's not free because the industrialists cannot say no. It is not fair because in that process, the political party in power gets the maximum capital and the capital it wants, not for elections, for other purposes. That's very dangerous. Incentivizing, and I'm come to the other main argument. Incentivizing, I won't take more than a few minutes, Malad. I don't want to trouble your lordships. Incentivizing the use of banking channels. Of course, you will get this legitimate money through banking channels. In fact, that's the perfectly rational way of enriching yourself. Perfectly rational way. But that's not a justification for empowering yourself. I can understand if there was a correlation between this and the election process, in which you must disclose how much you have spent, where you have spent. But that cannot be because it is the candidate who is fighting the election, not the political party. As far as persecuting the person who has been given the money by that party to an opposite party, they will be persecuted. But why will they be persecuted? Well, let me tell your lordships, just to tell your lordships what the reality is. A big industrialist who has enormous power will give it to all political parties. And the party at the center will never hold it against that industrialist. Because everybody is benefited. The system enjoys this money. Enormous capital to the party that is in the center and small little donations to the others. And everybody knows about it. It's not a secret. So there'll be no retributions that why did you give it to that party? Because you've also got the maximum. Why should there be a retribution? So this whole argument that no, there'll be a retribution, why have you given to that party? Supposing, Maharaj, I have got 100 crores. I get 100 crores, but the donation shows that he has given 500 crores. I know that 100 crores come to me, 400 crores have gone somewhere else. And if, Maharaj, for the 100 crores, the quid pro quo is 4, 5, 6 instances, Maharaj, then out of 400 crores, why should the retribution be more than just 4, 5, 6 instances? The same logic will apply. Same logic will apply. So why are you protecting those, Maharaj? And the most serious part, Maharaj, which I said earlier, that I will never be able to go to a court of law. What you're doing is giving a protection to corrupt transactions by not putting that information in the public domain, because I will never know. So, Maharaj, how do I move forward? Where do I go? I can't file an FIR because I don't know. I'll be subject to defamation. I can't go to court. I have under 156.3, I'll have to go to, I'll have to give some data. I don't have the data. So what court order are we talking about? Don't shield the process of corruption itself by allowing this to go on. If you want to deal with corruption, the first thing to do is to quash this scheme. This is the surest way for political perpetuity. Having said that, just 5 more minutes. Then, Maharaj, the respondents argue that EBS is a matter of financial economic policy. It certainly is not. It deals with elections, nothing to do with financial policy. In fact, the EBS and amendments on which it is based changes the very ground rules of the electoral process. The very ground rules, which negates any presumption of constitutionality and on the contrary requires heightened judicial scrutiny. That's the answer to that question of financial and economic policy. Economic policy in the bearer bonds issue because that way you can bring black money into the economic system and pay tax on it. This has nothing to do with it. 2, he said, they argue that making the identity of donors an extension of secret ballot, the right to vote and donating of funds are distinct. The right to vote is secret ballot. Donation of funds cannot ever be secret. 3, he says, there is no uneven playing field. I will demonstrate it to yourself. The entire field is uneven. 4, they say the respondent has distinguished ADR and PUCL on the ground that the information sought for in those cases already existed and just needed to be disclosed. In this case, the only reason the information about the identity of donors is unknown in the present case is the structural design of the system. You have structured the scheme in such a way that it's unknown. So, I really don't want to say anything more. All I can say is, and what is the public interest that is being served here? I don't understand what the public interest is. Public interest not to know, not to disclose. And who are you protecting? For what purpose are you protecting these people? You are actually protecting yourself. Because you know who has donated. It is self-protection, self-preservation, self-perpetuity. How can the public interest in protecting the identity of donors outweigh the public interest in the public's right to know? To be free from corruption. So politics, Malaj, as I said, it's impossible for us to get rid of free money, black money, Malaj. No country in the world has got rid of it. Let's be clear on it. All your lordships can do is to tell the government, this is not the way forward. You want to deal with it in a way that is transparent, that gives us the confidence that it is not for you, it is for the larger public interest. Thank you very much.
Thank you, Mr. Siddharth.
Malaj, also, I would say, I filed rejoinder submissions already to his submissions, Malaj. A court master may just upload them. All that I have said to your lordships is dealt with that in about 12 pages. I'll give you a copy because I didn't want to take too much time to read them. There are others also. I'm deeply impressed.
The core of our challenge is to the
Yes, Mr. Siddharth.
To the statutory provisions which prevent public disclosure. Those are the statutory amendments. The scheme follows based on those amendments, namely amendment to section 29C of the Representations of People Act and section 182 of the Companies Act. Those were the public disclosure provisions. The scheme, once the public disclosure comes with the scheme, there is no real scheme to survive. Now, this is to answer my Lord Justice Khanna's question, what are we challenging? We are challenging those 2 statutory provisions because once that goes, the scheme itself collapses. The basis of the scheme is non-public disclosure. Because with that, I would submit why do we need in rejoinder 2 points only. Why do we need public disclosure? Because number 1, as the US Supreme Court said in Buckley versus Valeo, a political party may represent anything to the electorate. It may self-ascribe any label to itself to the electorate. But one of the best ways of determining what the party is about is where or who it is going to be most responsive to is where it gets its funds from. If that aspect itself is removed from the public domain, so a party can say X, take the money from Y or other interests, and the public has no way of knowing. So public information is necessary for voter to form its view into voting. That is a substantive right to vote, is an informed right to vote. And therefore that information as to who has given you money to, so that the voter can match what you are saying. Are you taking money? Are you a green party? You're claiming to be a green party, but taking money from oil interest. There are n number of examples. So that is one interest which is necessary. Second, Manoj, the question fell from the court yesterday to the government that how will you prevent quid pro quo? Manoj, quid pro quo has been used by both sides very broadly. Let me just try and bifurcate it. Manoj, one would be Manoj, policy influence or policy capture. Strictly not corruption. Second will be legislative influence or legislative capture. Strictly not corruption either. Plus, the final stage would be corruption or bribery. Plus, the only, in my respectful submission, the only constitutional safeguard against preventing quid pro quo is, in fact, public disclosure. And one constitutional court in South Africa, I just want to place two paras. In rejoinder, normally I wouldn't place paras of a judgment. Only two paras because exact same situation arose in South Africa. And the Constitutional Court of South Africa has said that the only way to ensure that these other things, because nothing can be removed in a polity, is a complex space. Surely we can't expect a perfect world. But from areas or zones of influence to movement to zone of corruption, that can be prevented by public disclosure. Your Lordships will just have page 6654. 6654, volume 4. Volume 5, I'm sorry, my apologies. Plus, the case is titled, quite aptly, My Vote Counts versus Minister of Justice. And straight away, para 40 at page 6653.
What page does this case begin? 66?
Well, 6653 is the relevant portion. Bookmark number 60, 60.
Yes.
This is volume 4 of?
Volume 5, my lords. Volume 5. Plus para 40. As the court has it. The reality is that private funders do not thoughtlessly throw their resources around. They do so for a reason and quite strategically. Some pour in their resources because the policies of a particular party or independent candidate resonate with their world outlook or ideology. Others do so hoping to influence the policy direction of those they support to advance personal or sectional interests. Money is the tool they use to secure the special favors or selfishly manipulate those who are required to serve and treat all citizens equally. Unchecked or secret private funding from all, including other nations, could undermine the fulfillment of constitutional obligations by political parties or independent candidates so funded, and by extension, our nation's rightful place. Then thereafter, our freely elected representatives must thus be so free that they would be able to focus and deliver to their core constitutional mandate. They cannot help build a free society if they are themselves not free of hidden potential bondage or captivation. Now, para 42 is important. I'll read only from the third line. Only when there is a risk of being exposed for receiving funding from dubious characters or entities that could influence them negatively for the advancement of personal or sectoral interests would all political parties and independent candidates be constrained to steer clear of such funders and be free to honor their declared priorities and constitutional obligation. And that risk would enable by a regime that compels the disclosure of information on the private funding of political players. So, my respectful submission is public disclosure is the real check. Public disclosure is the real check. And therefore, from all the kind of things which happen in politics, from that to moving into the zone of corruption. And in a democracy, it's the public which tests the party every day. Plus, effectively, that is the biggest check. Plus, finally, an argument on confidentiality was made. A certain formulation of that was made on privacy. Plus, and a comparison was made to right to vote is a secret right to vote. And therefore, this by extension you should have a secret right to fund. In effect, if I understood, that was the formulation. Our respectful submission is right to vote is your own exercise of franchise. It's the least level of participation as a political actor in a democracy. The minute your levels of participation starts increasing, if I want to fund and influence the system as a whole, of course, I cannot be claiming privacy or confidentiality. If I'm holding a public office, my level of confidentiality or privacy will be restricted to my family zone. So, this privacy, even in respect, of course, corporations don't have a right to privacy. It's Article 21 right, flows from right to life. So that is out. But even assuming natural persons who may be donating, their right to privacy can certainly, or right to confidentiality, whichever way we frame it, cannot extend to an area where they will now impact the entire political system and seek to do so secretly as a matter of right. Of course, it cannot be. So, as we go up the system, in terms of our political influence, the proportionality doctrine will ensure that your ability to assert confidentiality or privacy as a right is reduced. Finally, I'll just conclude by one quote. Thomas Jefferson, and my learned friend Mr. Bhatia says that the best protection against victimization is full transparency. So that, just want to emphasize that. And finally, I would just like to end with a quote by Thomas Jefferson. He said, information is the currency of democracy. And someone added to that quote saying its non-disclosure should always be suspect. I'm grateful, Manoj.
Thank you. Yes, Mr.
Lordship, I apologize for being on VC, Lordship. I
Usually don't give rejoinders, but I have no objection.
As an intervener, not technically, right, but let me have something to add, my lord.
Lordship, I just wish to take 5 minutes for one of the petitioners.
Let Mr. Khansare conclude. Yes, Mr.
Please,
Khansare.
Just a minute. Yes. My lord, the two quotes which my learned friend, Mr. Solicitor, started saying, practicality requires that I contribute to political parties. Practicality required, these are from the quotation because now we have the advantage of YouTube and the transcript. Require I contribute with a degree of confidentiality so that I am not victimized in future. Lord, this is the whole basis, my lord, of the scheme. Lord, my submission is, my lord, we are talking of political parties. We are not talking of rival groups who are collecting money. And the political parties fight election on the basis of their development activities, maybe on freebies, maybe on caste census, but not, my lord, that we will victimize a political person, a person who does not pay us, at least who's paying someone else more. Lord, the whole foundation is, my lord, there is a confidentiality, otherwise there will be victimization. Lord, with great amount of respect, my lord, nobody is coming forward to say, my lord, the rival group will be victimized. The government is trying to justify it, my lord, with this contribution, with confidentiality. And the other justification is, my lord, my learned friend has some difficulty in using the opaqueness or, my lord, the anonymity. He said confidentiality. Very well, my lord. Confidentiality of 100 or 1,000 corporate houses, would it, my lord, override the right of information of 140 people of this country, my lord?
That is already argued.
No, my lord, what they said, my lord, yes, the confidentiality is the key, is the required. Confidentiality of 100 or 1,000 corporate houses is required. But, my lord, my submission is right of the citizens would override, my lord, overweigh the right of the donors. How can you say, my lord, the 140 crores people's right, I will not take into account. I'll take into account the right of the 1,000, my lord, or 100, my lord, or 5,000 corporate houses. Thirdly, my lord, the black money Mr. Sibbal has given, Lord, I will give in a chart, my lord, of the RBI guide, my lord, from the RBI source. The amount of money was, my lord, in 18 lakh crore cash in 17-18 when the scheme was introduced, and today 22-23 it is 33 lakh crores. My lord, the details are given with the page numbers with a tabulated form in a chart to the court master. My lord, lordship would, my lord, just take into account, if your lordship to take that, my lord, the black money has not gone or cash money has not gone. Fourth, my lord, my learned friend Mr. Mehta said that what will happen is pre-2017 era. And he gave the figures from 2004 to 2014-15, where, my lord, he did not name, the BJP got 65% from undisclosed source. Presently also, my chart at page 59 says in my written submission, 65% is from undisclosed source, presented by them. The same amount of undisclosed source remains, my lord, even with this scheme. And finally, my lord, as a citizen, I must say, my lord, that my learned friend Mr. Mehta said this was the best solution we found. As a citizen, my lord, the best solution would be no cash donation. My learned friend says digitization has gone in our country 9 times more than Europe and US together, 5 times more than China. Let there be no no cash transactions, my lord. It will stop. Everybody would know it.
Thank you, Mr.
I'm extremely grateful to your lordship, lord, and it's
Yes,
very
Mr.
difficult for
Pasha.
me, lord, after 4
The last word for you, Mr. Pasha.
Thank you, Lordship. Lordship, I apologize first for not being present in person. It was because of an injury. Otherwise, I would have been there before my lords in person. Lordship, just 2 very short points. With respect to funding through subsidiaries by foreign companies, Lordship, there has been an attempt to misconstrue the scope of my lord's order segregating issues. Now, the order that had been passed by my lords in which these issues had been segregated, my lords had said that the Finance Act 2016 and the Finance Act 2018 and the amendments it brought about to the FCRA will be placed before a separate bench. Lordship, now what was amended in 2016 and 2018 Finance Acts in the FCRA was the definition of foreign source to exclude from a foreign source those companies which had foreign investment. However, Lordship, I wish to point out that where we are, minus the electoral bond scheme, even assuming those 2 amendments to the Finance Act stand, is that each foreign source, whether there are 4 major sources through which foreign investment comes into the country, Lordship. One is foreign direct investment, one is foreign venture capital investment, one is foreign institutional investment, and one is external commercial borrowing. Each one of these, Lordships, and I have placed the regulatory guidelines and the regulatory mechanism for each of these in volume 4 along with my written submissions. So the FEMA external commercial borrowing regulation 2018, the SEBI FVCI regulations, the SEBI FII regulations, and the SEBI non-debt instrument regulations, all of which, Lordship, cover ECB, which is external commercial borrowing, FII, foreign institutional investors, FVCI, foreign venture capital investors, and FDI, which is foreign direct investment. Lordship, for each of these, and I would point out the page numbers of the regulatory mechanisms and the schemes and the regulators who are appointed, but very broadly, Lordship, that for the end use of the funds that come in, including which company they're investing in, that has to be placed before SEBI and the stock exchanges. Same for FVCI, foreign venture capital investors, which is also SEBI regulations, where SEBI is the regulator, and the regulatory mechanism requires a full disclosure of where the funds are being placed. For external commercial borrowing, Lordship, RBI is the regulator, and the external commercial borrowing regulations require.
You didn't go into this. Thank you.
No, Lordship, I just finished my sentence, Lordship.
Only one line, my lords.
Lordship, if it's not for the bond scheme,
Only one line, my lord, if your lordship permits.
Lordship, I just finished one line, Lordship, and I'm done with my submissions. If not for the
Election Commission to get the data in accordance with the order dated 12th of April 2019 for the period ending 30th of September 2023. On 12th, ऐसा लिख लीजिए.
Only one
we have heard arguments on behalf of the contesting parties. Arguments are concluded and the judgment is reserved. Next, on 12 April 2019, an interim direction was issued by this court to the Election Commission of India. Full stop. The Election Commission has produced in a sealed packet, it's data as of the data in terms of the interim order as of April 2019. Full stop. The order of this court was not restricted to the date on which it was pronounced. Full stop. If there was any ambiguity, it was necessary for the Election Commission to seek a clarification from this court. Full stop. In any event, we now direct that the Election Commission shall produce up-to-date data until 30 September 2023 in terms of the interim directions which were issued on 12 April 2019. Full stop. This exercise shall be concluded, shall be carried out within a period of 2 weeks on or before Karlo. The data in a sealed packet shall be handed over to the Registrar Judicial of this court.
Not only one line.
Lordship, may I conclude that thought and Lordship will
I
then
think
see
I'll
if
be
it's
feeling in
relevant
my
or not.
duty if I don't say this. But I was little perturbed when Mr. Sibal said that there is no possibility of eradication of black money in this country. I am not that pessimistic. But the way in which digitized payment has increased, it is significant improvement and the country should not be pessimistic. We are in the process and we will eradicate black money.
Lordship, may I conclude
Thank
just
you all
the
the-
one sentence?
Thank you very much. Thank you very much.
But one more suggestion, it's my suggestion. But despite, my lord, my saying about SBI, etc., if your lordship's conscience, my lord, is desires to be satisfied more, your lordships may consider RBI, which is a statutory banker's bank. There may be some administrative issues instead of SBI because they may or may not have presence all over, my lord. This is just to show my bona fides. That's
Please,